How y'all doing? Oh my God, what a Friday. For those that are just tuning in, number one, hey, it's me, AV. Welcome back to my YouTube channel where we talk about all things law, true crime, and debauchery. Man, listen, we're about to jump into Yella Beezy because with these cases, you never know what happens. You never know what happens. I just heard that the Courtney Clenny case, the white girl that threw the knife at the black man and he died. She just took a plea. And I'm like, well, shit. What's up with the August cases? Because is Keefe D gonna take a plea? Who else gonna take a plea? It's about to get crazy. It's about to get crazy. So I am so excited to be here. We haven't streamed in a long time. I've been waiting for all of the Yella Beezy stuff to pile up, so to speak, and then we can review it. So here's the game plan for today. There were a series of hearings last week that were televised, but they were low-key televised. Right now, Law and Crime is just focused on this damn case in my state right now. Like literally, the it's not Clency. But I don't like doing cases with kids. I really don't like doing cases with kids. So it's one of those things where you have to be careful because, out of respect for the families involved, when the victims are children, I don't really like it. So I'm definitely not doing that one. Also, it's getting tight. This month of August has so many cases. One, Keefe D has literally he got 11 days. I hope this ninja don't plead out. I hope he doesn't. I hope he doesn't. Take it to trial, Keefe D. We need to hear all the tea. We need to hear about Diddy, all of that. Okay, you got Dirk. You got Dirk scheduled to go to trial. You know Dirk's taking it to trial if he got Steele and all these dream team attorneys on his team. So you know that one's gonna stay. But as far as Yella Beezy, he's taking it to trial too. So the game plan for today is we're going to watch the next 2 hours of hearings. I'm going to go through the hearings. We are going to speed it up slightly so that way we can get through it a little bit faster. And I have all of the motions the judge has ruled on. Okay. Beezy's trial is towards the end of the month. Okay. This is in connection with the death of rapper Mo3. Okay. This might be new to a lot of people. It's a little new to me, but looking at the trial slate this month, we're getting creative. I'm getting prepared for it. I already hired a new person. I was like, God damn it, I'm not going to be able to be in 7 places at the same time. So we have hired someone to help us out with getting you guys day-to-day courtroom, either footage or updates every day on all of these cases that are happening. With that being said, let us jump into what happened with Beezy last week. We're going to start with the first hearing. We're going to watch it together. I do have all of the motions that the judge ruled upon. She did deny some of them and approve some of them. And this is why I do like watching cases even at the beginning, even these pre-trial things, because you can see what the likelihood is of something actually attaching and taking it to trial. I will say I'm very surprised. I just learned. I was just over on Cat Not Williams' channel. I was like, oh my God, she took a plea. I thought this girl was gonna go to trial. She's not. I'll be honest. I did not see that coming. That was a surprise. And see, that's what the prison system is designed to do in a way as well. If you are incarcerated leading up to your trial, a lot of times what they do is they will try to, have the defendant get a little tired of being in there and make a decision, right? So we're seeing a lot more of that. But anyway, let us jump into this Beezy thing and go from there. This is the first hearing that took place last week. Again, Law and Crime was not in the room, so you're not going to get the usual things. We don't have the best view. I'm going to put the audio booster on, but we are looking from the back of the courtroom. And in addition to being in the back of the courtroom, I don't know why the cameraman is looking through this little sliver, but this little sliver in the back, but we're going to make it work. All right, we could skip all of this bad sound. Judge is gone. They stabilize. We got
right here and pick her up.
an abundance of TiVo time. She got a fan in the back. Okay, the judge has a fan in the back. This looks like it's going to be a good hearing. They get started. She sits down right around here. Okay. You know a judge is serious when she has a sign that says, "Please ask before approaching the bench. Don't play with me." This is going to be great.
All right, we have some logistical issues, so we're gonna wait a few more minutes.
I'm actually happy I'm watching this from the future, so we didn't have to wait for all of this back then. So here we go. Looks like the fan is still back there. We have Yella Beezy, I believe. I don't know if that's him. I can't tell just yet. But interesting courtroom setup. We have, is that a criminal defendant? Let's see.
Trial, the state of Texas versus Kewan White. Is that your name, sir?
Yeah, well.
All right, will the attorney announce their presence?
Bree West on behalf of Mr. White. Myra McIntyre on behalf of Mr. White.
Ricardo Vela on behalf of the state. Tommy Adams, state of Texas.
Thank you. And Mr. White's cases are set on the court's docket today for pretrial hearing. Have both sides filed their pretrial motions?
Yes, Your Honor, and the state does have one additional agreed order that I had sent to defense. I have not filed it because it's not, we haven't agreed on it yet, but I did send an agreed order to all defense counsel. This will encompass Mr. Conway and Mr. Brown's cases as well. That's the only thing we have left outstanding as it relates to Mr. White. Our motions were previously ruled on in either January or February of this year, I believe.
And in response to that, Your Honor, it's my understanding, and I think the state can potentially correct me, it's my understanding that there may be some amended or updated 404B notice that will be provided to us that really directly sort of addresses our motion for 404B and extraneous offenses and motions in limine.
And I don't have any of your motions in front of me at this time. I know I ruled on the state's motions the last time we had a pretrial.
Correct.
And the defense hadn't yet filed their motions.
I'm happy to print those and provide those for the court, Your Honor.
Okay, where are they?
They are e-filed. I can email them to you if that would be easier for the court, but they are on.
You emailed them yesterday? You e-filed them yesterday?
Yes, I didn't email them to you directly, Your Honor.
Okay. Has the state had an opportunity to review those motions?
No, Your Honor. They came in, I believe, after hours, and I was not able to review them this morning. Myself and Mr. Vela have begun reviewing the motions filed by defense, and I believe we could probably address those today.
Okay.
We would probably need an hour break or so just to review what we can and cannot agree to as far as motions.
Okay. And this agreed order that you speak about, what is it?
Yes,
what does it entail?
The agreed order that we've provided to all the attorneys is, I know this court is very well aware that the state, on our cases, we will provide a motion or an order as far as us turning over criminal histories as it relates to individuals. A lot of times that is asked by defense in their motions anyways. So sometimes, or most of the time, we will file an order, agreed order to turn over the criminal histories in our possession. Otherwise, we can't. So that is encompassed in this agreed order. Also includes text gang database information
Why would I need to sign an agreed order for something that the state is already duty bound to provide to
The law actually,
Go ahead, Auntie. She's gonna be a good judge. She's gonna be a good judge. This is like one of your tias growing up. Like this might be a good judge. I'm excited for this case too. Hopefully, KPD is 2 weeks. That the Tupac trial is actually slated for 4 weeks, so there might be some overlap with this one. But you can see that the Yella Beezy judge, she is not playing around with these attorneys.
as it relates for our CJIS compliance and our compliance with the text gang database, and as well as our compliance with NCIC, TCIC, and our access to that, it has to be ordered by the court that we turn those things over. We cannot just willfully turn over those things. Those are a lot like, for example, one of the other things in here is mental health records, health records, as it relates to individuals. Like those are things that a court would have to order us to turn over. Just like, for
Yes, and I usually do. I order the state to turn those over pursuant to discovery.
sure,
Michael Morton. I don't need a separate order to do that. And I'm not asking y'all to turn over the TCIC, NCIC records, just information from those databases with any criminal history that you know of,
sure.
that you've researched.
And just to make things, in my experience in handling these, especially with the amount of discovery we have, typically what I will do, Your Honor, I will run every witness that we intend on calling, civilian witness that we intend on calling, we'll typically run them the Friday before trial. That way we have a very clean, fresh NCIC, TCIC, as well as any text gang database information. And then I will turn that over via text share to defense. Of course, 3914, restricts their ability to hand that out, but that ensures that.
But you want to hand it out.
I would, yes, via text share, and speaking with our lieutenant who handles our CJIS compliance, and as well as speaking with DPS and who handles their text gang database, everybody's on board that this is an okay way for us to do it. And then that way defense counsel isn't relying on me transcribing or reducing the NCICTC into writing into what I believe it says or shows. That way they have all that information exactly as it is represented on the NCIC, TCIC, as it is represented on the text gang pronounced if there are any.
And shout out to Anastasia with the T. I did not know that Yella Beezy's attorney represented Carmelo Anthony. Wow.
And that way I'm out of creating a record or a document that they are then relying upon. Because I don't want anybody to have to rely upon any document that I'm creating or reducing something into a form. So this, in my experience, has been the easiest way to handle things, and has been my practice at least since before the pandemic. Maybe even 2017 or 2018.
Well, let me ask the defense, is that the format that you would prefer, or would you prefer for the state to review those records and inform you of whatever criminal history their law enforcement and civilian witnesses have?
So, Your Honor, I think it has a lot to do with like how voluminous it might be.
Right.
And so that and the only other issue I would have is if it is voluminous and we receive it the Friday before trial, then how are we to investigate or address anything that may come up for impeachment purposes that may be contained in that NCIC?
And just to clarify, the two parts. Number one, if this agreed order, we could agree to it, I'm happy just making everything that I have now.
I'm sorry to interrupt, guys. What the hell is Law and Crime doing this week and last week too? I know they're focused on this woman in Massachusetts, but like, look at what we have right now. This is the Yella Beezy Mo trial, right? And we have a cameraman all the way in the back with the smoky, hazy screen. We can't see what anybody is saying. I mean, what are y'all doing? Get in there. Get in the courtrooms. This is how we watch everything. And then on top of that, there's KPD footage that they're sitting on from Tuesday. I've been waiting for it all week. But instead, they're going for the high profile trials, which I get. But man, law and crime is slacking because what happens and this is not a slight at Fox 4 in Dallas. But why is the cameraman in the back of the room? Like put him in a proper place. This is like you're in the cut. You're in a cupboard shooting. You know what I mean? Just shooting and you're shooting footage and like you're going to see some shadows and things. And for those that are coming in late, I am covering all of the Yella Beezy trial pre-trial hearings from last week. There were about 3 of them. I'm skipping through all the breaks. I thought it was going to be about 2 hours of footage, but it looks like it might just be 1 with me skipping through everything. And then I'm going to go through what the judge ruled on this week, even up to today. I think she had some rulings today, yesterday, what's coming in. There is a witness list, and y'all going to love this. Guess how many people are on the witness list? 194. Trial starts in 3 weeks. Imagine being a defense attorney trying to get ready for that. This is crazy. This is crazy. But law and crime, what are y'all doing? Like, get back in courtrooms. Do y'all need some people to hire? Do we need to hire more cameramen? You got to be everywhere. You got to have multiple trials running at the same damn time. What is this?
That is in our possession as of today, making it discoverable today. As far as the civilian witnesses that we have histories for and criminal records for, that way they have a month to investigate it. The only reason I do it on the Friday before is just to ensure if somebody picked up a case in the 31 days between now and the start of trial. That is just to, again, give the defense a fair trial. And I would also like to clarify, we do not run criminal histories on law enforcement officers. Our office has a procedure where we...
Your Brady department?
Yes, we run,
Okay.
I will have all of my officers run through our Brady division that runs all of the officers, and I will turn over any information that comes back from them. We do not run NCIC, TCIC on all.
Well, regardless of that, regardless of what your Brady department does, I'm ordering the state to turn over any criminal history that any of your law enforcement witnesses have. It's your duty to discover that, whichever way you need to, and turn that over to the defense, regardless of your Brady department.
Well, in your honor, I would direct the court to, and I can get the citation for the court. I believe Ms. West was actually the prosecutor in the court for a case. It's entitled In Ray Watkins. I believe Ms. West was actually ordered to do the same thing, and the Court of Criminal Appeals came back and said that that would cause us to create records that are not in our possession. And I would just direct the court to that.
No, I think there's a difference here. I'm not asking you to create records that are not in your possession. I'm asking you that if there's any criminal history known to you,
Sure.
which you are duty bound to discover,
Absolutely.
that the defense can use to impeach your witnesses, whether they're law enforcement or civilian witnesses, you are to discover those and turn them over to the defense. I'm not asking you to create a document or create discovery. I'm asking you to hand over what exists.
I,
Okay.
I, of course, will comply with all my obligations under 30.
As you should, yes.
And Brady. I'm not trying to argue that. I just want to make sure that we're clear.
Yes.
If there's anything ever known to us, we would, of course, turn it over. However,
And anything that you should discover
sure. I completely agree. with all that.
proactively.
Just so we're clear, is the court ordering the state to run every single witness through a database?
No, what I'm asking you to do is if there's any law enforcement witness that you have that you're going to call and they have a criminal history
Correct.
or any material information that can be used to impeach them or that's beneficial for the defense, you are to turn that over to the defense.
Correct.
I think my ruling's clear.
I'm not even gonna hold you guys. I like her already. I like this judge already. I do, because you do not often see judges that will put the prosecution's feet to the fire. We haven't seen that in a long time. To be honest, we haven't seen it since the YSL trial, and that was with a judge change. Okay, y'all remember Glanville. But then when Judge Whitaker came in, she was not playing with Miss Love. Y'all know what I'm talking about. You remember Mook Toonk? I'm wearing a Legacy shirt right now. You hurt my brain, Miss Love, because you asking all these questions. It doesn't make sense. We don't see judges like this often. So I actually am liking Auntie so far. I think she's going to be fair. I can see that. But again, we've only just watched this for a few minutes and she's starting with the state. So let's evaluate a little bit more and go from there.
Thank you, Your Honor.
All right. Okay, what next?
And that agreed order also, again, contains turning over medical reports, mental health, psychiatric records, just in the process of subpoenaing records. Typically, these would be orders that would be put forth individually. We have just put these together in one small format to not waste paper and have 3 separate orders, and just that we want to disclose all of this to defense and the other parties.
But you're already duty bound to disclose all that. What I'm asking is, why do I need to sign a separate order for that?
There are certain things that require, it is our opinion, that the court would have to order us or grant a motion or an order for us to turn things over, much like grand jury records. They require a particular cause being shown or particularized need, excuse me, Your Honor.
I'm assuming that's all in the defendant's motions.
Yes, Your Honor.
Yes, Your Honor. So the 2 statutes we're talking about require orders from the court, similar to as.
Pre-trial orders, right?
I'm sorry?
Pre-trial orders.
Correct, Your Honor.
Correct.
Which is why we're asking the court to sign an order so that we have an order in place.
When I rule on defendant's motions, those items that you're talking about, those issues, they will be covered in those motions.
Sure.
Usually.
And
And
Your
I will
Honor,
order the state to turn all that over.
and again,
My
Your Honor,
question again is, why do I need a separate order?
on Monday of this week, when I sent this to defense counsel, Ms. West, Ms. McIntosh, Ms. Evans, Mr. E, I had not received any motions for pretrial regarding either of them, and had not received them up until last night. So
I'll tell you what, let's hold up on that.
that's fine.
Ms. West, go ahead and, well, you already have the defendant's motions, correct?
We have them now, Your Honor.
Okay, go ahead. So y'all review that, and then in an hour's time, we can come back and I'll give my rulings on the defendant's motions.
Thank you, Your Honor.
Okay.
The other, I think, and I don't know whether or not this is going to be out of order, but the other thing was, I believe that our client, Mr. White, Mr. Conway, and Mr. Brown are all set for trial on
The same day.
August 24th.
Yeah.
And so we did want to, and I don't know if the court wants to hear any arguments about that at this time, or if we should do it later.
We can do that now. From talking to the parties, I think after the last pretrial we had, the understanding was that Mr. White's case would proceed first. Has anything changed?
There you are.
Yes, Your Honor.
What's changed?
And I do want to, if I may, make the record clear. At the time that I think we addressed the order of the trials with the court, Mr. George Ashford was on the case, and it was prior to Ms. McIntosh, number 1. So I want to make sure that that's clear. So I don't believe that the defense indicated a desire for this case to proceed, for Mr. White's case to proceed before any others. But since that time, Mr. Conway has had a very extensive pretrial hearing that had to do with rap lyrics, it had to do with various extraneous allegations, it had to do with other rap artists within the community that are unindicted but being referred to as co-conspirators. But at the center of this case is whether or not there was a payment made to my client by another person. It appears to us that what was raised during his pretrial about the rap lyrics and money being exchanged and various people meeting up or allegations of that his defense counsel undoubtedly will develop a pretty robust defense regarding that.
Regarding rap lyrics and
regarding the entirety of the allegation of whether or not there was a payment made.
yes, of course, that's the central
That's
theme,
right.
right?
Yes. And because Mr. Conway's attorneys undoubtedly are going to develop a robust defense, we believe that there may be information that comes out during Mr. Conway's trial that will directly impact our ability to develop a robust defense. Now, I don't want to misrepresent. We're not suggesting that the state of Texas is withholding evidence as it relates to whatever it is that they may know. But as the court is well aware, Mr. Conway's attorneys have absolutely no duty to disclose anything to the state about what their defense is, or anything to any of the other co-defendant attorneys about what their defense may be. And it may be that the only way that we can discover that there is some alternative theory, that there is some other evidence that exists that would benefit our client in his defense is through that trial, is through Mr. Conway's trial. So as a result, we believe that the only way that Mr. White can really develop a full and fair defense, and that we have our duty to protect his constitutional rights and all of that kind of stuff, the only way that we can do that is if Mr. Conway's case is able to proceed forward, and that we can glean any beneficial evidence through that trial in favor of Mr. White.
And I may add, as the court knows, remuneration and shooting is two of the major elements here. Remuneration, there may be financial records that Mr. Conway and his attorneys are in possession of that they don't have a duty and obligation to share with anyone, not even to the state or the court prior to the court proceedings. If that is entered into evidence after Mr. White goes to trial, then he would be at a disadvantage. And it would be unfair justice for Mr. White because we weren't privy to that information. And if Mr. Conway, if that evidence leans a not guilty or whatever.
All right. So this is interesting, chat, because what's happening here is you have a few people kind of similar to YSL in a sense, kind of similar to Julio Fulio. You have multiple defendants. Okay. I didn't realize that there were other co-defendants. I'm kind of going into this blind, and I want to, because it does allow me to give you guys a objective viewpoint legally on this case, right? Just watching it and reacting to it raw dog. That's what she said. Now, it appears that both of these women that are up there right now are different attorneys. So you have defendant White, defendant Conway, defendant Brown. The issue is when you have severance and you have co-defendants and one person wants their trial first compared to the others, and we saw that with Julio Fulio, Alicia Andrews' trial went first, and then the remaining 4 defendants were tried together. Okay, what happens is stuff comes out in Alicia's trial, and then fast forward a few months later, we see the Julio Fulio defendants, the remaining 4. We saw information come out in that trial that was different from the first trial, because when you have one defendant, it is purely focused on that defendant's guilt or innocence, right? Not the entire conspiracy. To the point where you guys just watched on this channel last month, Isaiah Chance get up and say, well, you know, at sentencing, Alicia got 15 years and, you know, me and her were doing the same thing. How come she got 15 years and I got life? So when these defense attorneys are going back and forth, like, hey, you know, there's certain information that could come out of this defendant's trial that I wouldn't have access to if my person goes by themselves, if my client goes by themselves. So it is interesting to see these dynamics play out in courtrooms. And that's why I find these pretrial hearings fascinating. And I also love the fact that this is an hour hearing, and really it's just like 20 minutes of content. I love TiVo time. It's amazing.
then the information that the state has given is pretty misleading. And at this point, we're asking that the case as it relates to remuneration goes first, that they might have more evidence that we don't have.
What's the state's response?
Multiple things, Your Honor, if I may. Going back to our conversations in January when we were set for the first week of February, I had made it known to this court that my intentions and our plan was to go on Q1Y. That was who we wanted to go to. He is the alleged shooter. And at that time, if the court will remember, we had an extensive conversation in chambers that Ms. McIntosh would be brought onto the case. I know she wasn't in the courtroom that day, but she was being brought on the case. We had appointed her as well. And the understanding, and I know we all love Mr. Ashford and wish he was here. But even at that time, the court was full aware of the situation that was going on there. And in chambers, you made it very clear to us in Ms. West that everybody would be ready for trial on August 24th. And you knew our position at that time. All of these defendants have been indicted for capital murder since March of 2025. Mr. White has been indicted for murder since January of 2021. Ms. West represented him in the Northern District of Texas and then was brought on with Mr. Ashford in 2021.
Right, I remember that conversation, and Ms. White has, Ms. West had access to a lot of discovery.
The majority of it.
Majority of it, yes, back then, even before.
Correct.
Yeah.
And Your Honor, at that time, if the court will remember, even prior to Mr. White being brought back, because if you remember, we brought him back on a writ of ad prosequendum from the federal government. And we had to have a hearing before you, and you signed off on that order. We had to get a trial date, and we made representations to the Bureau of Prisons and the federal government that we would be ready to go to trial on him first. And even then, once the court did it, Ms. West appropriately lodged her objections for multiple reasons, but brought up her fear and concern and safety of Mr. White being here in Dallas County Jail, and made it a big part of the record as far as his safety, and there's hits out for him, and that she wanted him to be housed at another location. And the court said, no, he'll be housed here. And so he came back and he's been here. And so at that point, we know now that he's in single cell. He has to be escorted by SRT. And so, Your Honor, part of that is disingenuous to now say, well, he's here. We want to even, I'm willing to put his safety at risk, I guess. And the jail is having to deal with him being in single cell. You know from prior hearings that he's going on YouTube Live and talking about evidence and discussing grand jury records and grand jury testimony. We've come before you and discussed that. Further, Your Honor, I don't understand, maybe I should, that all of this evidence that has been provided to the defense counsel, nothing has come out as far as rap or anything like that. The murder for remuneration has been the indictment since March of last year. Whatever Conway's attorneys do is what they do. I don't understand the idea of I get to sit back and see what goes on with their case to see how it might benefit my client. The defendant has been in custody since December 9th of 2020. I have a family that's sitting here that deserves justice. He was indicted in January 2021 for killing Melvin Noble. Yes, we enhanced the charges to capital murder last year. But based off of everything procedurally that has gone on with this case, and the fact that he is on loan from the federal government, that this court had to sign an order, and every single time we've had a setting, it's been another reason why this family cannot get justice. Whether they want to sit back and see what, I'm sure Mr. Conway, they're probably going to say they want to go first. I understand that. He's on bond. Wouldn't every co-defendant want to see if they can benefit from their co-defendant's trial because something else might come up that's good for them? Nothing new came off that stand as far as evidence that we are planning to admit. In Your Honor, we are asking the court to do what's right, not only by the criminal justice system, but by the family, and let this community hear this case of the man who's alleged of shooting and killing Melvin Noble on I-35 and is also charged with aggravated assault for shooting a neurosurgeon in the head that day on the freeway.
Oh my God. This case. Y'all just be recommending crazy cases. So you have three defendants: White, Conway, Brown. Yella Beezy is defendant Conway. He is out on bond right now. Okay. So he's currently not incarcerated. He's still at home. He's still at home. And this trial is about less than a month away, 3 weeks. So we'll see what happens here. But lyrics are coming in as evidence, things of the like. Mo, the decedent in this case, was killed on a highway. And we just heard from this prosecutor, and I'm going to bring it back. Because did I hear that whoever the shooter was went and killed a doctor? What? What? Where do y'all find these cases?
So the criminal justice system, but by the family, and let this community hear this case of the man who's alleged of shooting and killing Melvin Noble on I-35 and is also charged with aggravated assault for shooting a neurosurgeon in the head that day on the freeway.
Thank you.
May we respond, Your Honor?
Yes, go ahead.
Thank you. And just so the record is clear, it's my understanding that the only case that's moving forward to trial in terms of guilt innocence is the capital murder. So I appreciate the state saying that there are other allegations that are pending, but the only case that I've been told we're going to trial on is the capital murder charge. Furthermore, everything that Mr. Adams just talked about has nothing to do with the evidence in the case, which is what we're dealing with, and that's what speaks directly to Mr. White's ability to have a fair trial. The reality of the situation is the only evidence that the state of Texas can provide to us is the evidence that they have. That doesn't have anything to do with any evidence that may come out during Mr. Conway's trial that is identified by his own attorneys.
I mean, the same could be said for any of the co-defendants.
Well,
I mean, if I gave you all the choice to see who wants to go first, I don't think anybody would want to go first.
Well, I think that if you were to talk to some of the lawyers, there are some that want to go first. I do think that. And so I think that in this particular case, what Ms. McIntosh and I are trying to do is ensure that our client has a right, that we're starting at the same starting point, right? And I think that would include being able to get information.
Man, I love y'all. Shout out to Fonnie Willis in the chat. Like, y'all give it up for Fonnie. Y'all give it up for Fonnie. Fonnie says, AV, because of your courage, it costs us a strong conviction in the Young Thug trial. We want to hire you on my team. I can't stand y'all. I really can't. Let's go back in.
And that nobody has to know until trial as it relates to Mr. Conway.
Your client is the alleged shooter, correct?
Yes, Your Honor.
Your Honor, if I may,
Yes.
this case is different than most capital murders that the court may have seen in the fact that this is dealing with remuneration. And in the state's indictment, it says specifically that Marquise Conway paid Keyone White for remuneration. That means, and I'm a finance and accounting major, Your Honor, previously and working in finance and accounting, I know that there may be documents, there may be bank statements that the state is unaware that they might not know. And that may be provided or introduced in trial that from Marquise Conway's attorneys. And if we go first, Keyone White is up this stage. This has nothing to do with how long he's been in jail. He could be in jail for I'm sure that Mr. White, if he was to testify right now, would say, I want to make sure I have all the evidence before I proceed to trial, and I'm willing to wait prior to we're just going off of what the state has, what the state is alleging. Because that, I believe, could put Mr. White in a strong disadvantage. It unfairly prejudices him if we don't have all the information that Mr. Conway may have. And the only way we get that is if Mr. Conway goes first.
Your Honor, may I please respond?
Go ahead.
There has to be some correction here. First of all, I want to direct the court's attention that on July 14th, I was asked by Ms. West, actually I was asked on the 6th, Ms. West has a trial set on the 10th of August in the 283rd. Her and I had a conversation. She made representations that she knew that we were going first. And I believe she even put that on the record in the 283rd to get that case taken off the docket and get a continuance. And she can shake her head no in this courtroom, but we can get the record that she understood and knew that we wanted to go on her client first. That is not even up for a question, or I want to make sure that is very clear. She's made representations to other prosecutors in this office and another judge. Secondly, as far as
Okay,
documents,
allow him to finish.
Okay.
as far as documents that Mr. Conway may or may not have, they can subpoena records as well. Mr. White has been in custody since December 9th of 2020. He's been indicted for capital murder for a year and a half. They've had the opportunity to subpoena any and all records. And also as a finance major and having an MBA, yeah, there could be more records out there and they can go and seek those out. That's an obligation on them to their client. And finally, as far as Ms. McIntosh saying that if you were to testify right now, that he would say that he would want to wait. I listened to him on YouTube a whole bunch saying, I'm not going to trial. I'm not going to trial in August of this year. He doesn't want to go to trial. This is a game, Your Honor. It's a delay tactic in a game.
All right.
And I'm so sorry.
This is the last thing I'm going
Yes,
to hear about
Of
this.
course, I apologize. It's just that Mr. Adams put on the record suggesting I may have made misrepresentations to other members of the DA's office and to another judge. So I have to correct that. What I told, this case is set for August 24th. I have another case that was set August 10th. At the time that I was asking for that other case to be reset.
Man, this looked like Chat GPT regeneration. I'm sorry, y'all. Like, this is what I mean. Law and Crime has the best cameras. They have the best technology. And I'm so disappointed that they weren't in like cases like this. Like, I'm going to be honest. Like, they're not, they were all over Thug. They were all over ASAP Rocky, you know, but like, who's Yella Beezy? I don't know who that is. Oh, the Tupac trial. We don't need to be there for that. No, this is what happens when y'all are not in the room. Okay. And some of y'all told us that the reason why it looks foggy like this is because the camera person is behind plexiglass. And y'all saw Dr. Fauci plead the fifth. 1, 2, 3, 4, fifth. It doesn't matter what you say. Fifth. Dr. Fauci was pleading the fifth. The fact that we still have plexiglass in modern day courtrooms is crazy. It's crazy. So that is why we have the view that we have. Remember, the woman on the left in the black is representing defendant White. The woman who is not wearing a suit is Yella Beezy's attorney, okay? And she is arguing on this particular day. We got about 10 more minutes on this one. I'm going to bring us to the next day after this for the second hearing, and then we'll look at how this judge ruled in the case.
This court hadn't made a decision about which case was going. And so what I did represent is that I knew that Mr. Adams wanted to go forward on our case, which I did know. That had nothing to do with anything that came up after that, but it also had nothing to do with the fact that if I was in trial on a first-degree felony 2 weeks before this capital murder case that has 20 terabytes of discovery, then I'm putting both of my clients at a disadvantage. So that is what I put on the record, and I can get that record from that other court should it become necessary. Because
There'll be no need for that. There'll be no need for that.
If I may, this is, I'm highly disturbed because this is not a civil case. We don't know any information about Mr. Conway's records except what the state has provided. And we can't do depositions. We can't talk to Mr. Conway ourselves. So to say or even suggest that we could subpoena records that we don't even know exist, or whose name, what name, if he shares a bank account, what other information is going on, I think it's disingenuous. At the end of the day, if we don't know what records Mr. Conway is introducing or admitting into trial after the fact of Mr. White, he is prejudiced. It is probative that we have all the financial records and documents that is going to be introduced into Mr. Conway's trial. And as the prosecutor sits there today, he cannot say unequivocally that he knows all the evidence that Mr. Conway from his financial records is going to introduce into trial.
Okay. Now, you all are making all these arguments, but I've been an integral part of these discussions about what case is going first, the continuances, the reasons behind them, the discussions that we had in chambers regarding what cases moving forward. And so based on all that, Keywan White's case will go to trial first. So everybody be ready on Keywan White. So I'm going to give you all an hour to review the defendant's, Mr. White's motions. And let's reconvene at 11 o'clock. Okay? Is there anything else before we do that?
And we'll take up the other councils at that time as well.
Okay, Mr. Shook, did you have anything you wanted to say on the record? And this is Kewan White on the record this one. So this is.
Okay, so I said that wrong. These were attorneys for Kewan White. Sorry, this is the first defendant. Damn. So this is 53 minutes of a hearing, all on defendant White.
Counsel for co-defendant speaking. Go ahead.
Judge, on behalf of Mr. Conway Woodhouse, we are ready for trial and would like to go to trial.
Yes, I asked everybody, all of you to be ready. All the co-defendants shall be ready on that day in case something happens. Because, you know, as you all know, sometimes parties work out a deal and fall off, and then the next person would have to come up. So everybody be ready. So you're announcing ready?
Yes, sir. Yes, sir.
And Mr. Harris. Mr. Harris.
Yes, ma'am.
And Delane Evans?
Yes,
Okay, and you all will be ready on the 24th as well, correct?
we are ready.
Okay,
Stay ready, Judge.
okay, very good. All right, let's, we're off the record.
Just one line.
Okay.
I just said that to be on the record.
Okay, off the record, go ahead.
I did want to ask on the record at some point, a couple of statements regarding the matter we brought up with our last pre-trial with Mr. Adams.
Okay, I'll have to call up your case for that.
You want me to, do you want us to come back at 11 after you're done with that?
No, we shouldn't. Let's go ahead and handle that now. Okay. Yeah, Mr. White can go. All right, we're on the record. This is cause number. Where is Mr. Conway? He would step forward.
Oh, here we go. All right, now we got Beezy's team coming up. Let's see what happens here. I feel like I'm in the courtroom trying to see, like, what's going on? This camera sucks.
All right, this is cause number F2500154, State of Texas versus Marquise Conway. Is that your name? Let the attorneys announce their presence.
Cody Shook for defense.
John Bishop with defense.
Ricardo Vela for the state of Texas.
Tommy Adams, State of Texas.
Thank you. And Mr. Shook, you had certain things you wanted to put on the record today?
Yes, Your Honor. At our last pretrial hearing, we have requested, filed our motion about revealing any deals or benefits given to any of the witnesses that were testifying for the state. Mr. Adams had stated on the record that he had made no promises or benefits from the state, but could not state on the record that what the federal prosecutors had done. And I believe at that time he said, well, ask him to use due diligence to make inquiries into that. So I wanted to follow up on that aspect to see if there were had been any other, if he has new information regarding that, so we have a record of that. That's one of the issues.
Okay. So any updates by the state?
Yes, Sean. I actually sent defense an email yesterday, and I sent them one last week as well. As far as certain documents that are currently in, again, Your Honor, if there's any information that comes forward that deals were made either on my behalf, the state's behalf, of course, we would inform defense immediately. Nothing has changed as far as that is concerned. We have not made deals or cut any type of deals, made any promises with anybody as far as the state is concerned. However, Your Honor, as I brought up last time, we can't control the federal government and what they turn over and what they don't. I've made requests earlier this year and have continued to follow up with federal prosecutors regarding that information. I did send defense an email yesterday at 2:12 p.m. Regarding some of the information that they were, I believe that they're looking for. However, it did take a while because the federal prosecutors needed permission from the federal judge to release it. And so I forwarded that email to defense counsel as far as yesterday afternoon, and it lists the things that are available for them. And in fact, it lets them know that they can come by, but they will need to coordinate. And they can review it there at their office. They're not going to release those documents to us. The defense would have to coordinate with those federal prosecutors to go over and make a time to go review that information.
Okay. Mr. Shook, is that the information you received?
Yes, Your Honor, we did receive that email.
Okay.
The other issue, Judge, we talked with Mr. Adams on several occasions. He's indicated, as the court knows, there is a large amount of discovery in this case, some 16 terabytes. Mr. Adams has told us that he would meet with us and show us the exhibits and evidence that he plans on calling his case in chief. We have not mentioned that on the record. I just want that agreement by Mr. Adams put on the record so there is a record of it.
Okay.
We meant,
That the state will prepare an exhibit list?
well, that he will show us the exhibits he plans on using in his case in chief and go over the pieces of evidence, witnesses that he plans on calling.
Okay, and the court will require an exhibit list as well.
Absolutely, Your Honor. And just as I did last week for our hearing, I'm going to provide everybody with an exhibit list. And just as I did as far as this last hearing, I sent all of those exhibits to defense counsel via text share so they could see. Now, of course, I've started preparing those exhibits for the trial. I was working on that yesterday. Those will be uploaded as well for all of the attorneys. This doesn't just apply to Mr. Conway. I'm doing this for all of the defendants, so that everybody can be on the same page as far as the exhibits we intend on offering. These are intended exhibits.
Right.
There could be deviation, and this is not a smoke and mirrors or trying to trick anybody, but if the court will remember even from last week, I had a whole long list of exhibits, and there were some that I didn't put in, and then there was one that I had to add. I'm planning to give them as much as I can to show them the exhibits that we plan on it offering. Of course, we filed notice of intent to use business records. That's a good indication. However, I'm going to continue as we get closer to August 24th to provide them with these are the photos, these are the videos, and I will give them the evidence list that I will have here for the court and the court reporter as well, just to make this thing smooth and as streamlined as possible.
Right. I appreciate that.
Yes, Your Honor.
Anything else?
I believe the court has us scheduled for the trial date's August 24th, but there's another pre-trial date set for August 21st.
Well, yeah, if necessary, the parties can convene on that day. If there's anything else that comes up, I think we just scheduled that just in case.
As a check-in.
Right.
And Your Honor, if the court would remember, we did appear earlier this year, and we had discussions regarding these motions. We never got into the substance of the omnibus pre-trial motions, and I don't know how this happened, but an omnibus motion that had checks of certain
Right.
things had made it.
We discussed that, yes.
Correct.
That was a different, yes.
And the court had actually made a
Docket entry.
docket entry that we would take up. It was entered in error on the 9th.
Right.
Okay, so we still need to take up his, Mr. Conway's omnibus motions. I believe ours have all been ruled on.
Okay. Now, Mr. Shook, do you all intend to present that motion or? not?
Yes, I think we've come to agreements on most of them, but we'll have to discuss that again.
Okay, y'all talk about that in an hour. we'll talk about both, okay?
Thank you, Your
All
Honor.
right.
Thank you, Judge.
That's off the record.
Thank you.
Thank you.
We can tell you.
Joe, are we excused?
All right, so he's walking out there. This is the first hearing from last week. There's one more that's about it's an hour of footage, but I think we'll get through it in 30 minutes. For those that are coming in, we are watching the Yella Beezy hearings from last week. This is the first one, so we are now at halftime. We're going to go into the second one where we really get into the nitty gritty as far as lyrics being used as evidence. Big breaking news for anybody else that's coming in. Courtney Clenny, the woman, the OnlyFans model that was charged or at least supposed to go to trial for second-degree murder for killing her boyfriend, is now accepting a plea deal. It has been official. It's officially posted. Her next court date is on the 10th. We will be busy because that is the first day of the Tupac case. Okay, so August is crazy. I had to hire somebody for the team because I need to get another editor. There's just no way. We have a full editor that's going to be dedicated to the Tupac case and a full editor that's going to be dedicated to this one, the Yella Beezy case. And then on top of that, you have Dirk, who is starting the same week as Yella Beezy. Here's the problem with little Dirk. Dirk's trial is not going to be televised. It's going to be federal. And I'm already seeing a lot of journalists get kicked out of that courtroom. Last week, there was some hearings for the David case where the judge needed to decide if there was enough evidence to bring it to trial. David is not going to take place, I would say, in 2026. The David trial is probably going to be a 2027 case. But during our low months after this August season, maybe in September, I can start deep diving into the David case file because there's a lot there. There's a lot that was uncovered last week about David, this young singer who killed a 14-year-old girl, Celeste. And like I said, I don't like doing cases that involve kids. I really don't. But because David just lied flat out and all of this stuff is coming out, we might dive into that one. But for right now, my primary focus is on the Keefe D. I'm reading the book this weekend. This is one of the main pieces of evidence. He confessed in this book that he killed Tupac. I kid you not, it's so crazy. So we got a hearing next week on that one on the 4th, and then trial begins on the 10th. Yella Beezy, what we're watching right now, is scheduled to begin on the 24th, and Dirk also will be on the 24th. But again, we have some complications with that one with not having eyes in the courtroom. I think I have one reporter person, but I'm going to have to debrief with them every day to make videos with you guys since we will not have eyes in the courtroom. David is not federal, but because Celeste was a minor, and you guys did see this for those that are watching from Texas, you might have seen this in the Carmelo Anthony trial. When there are cases involving minors, it is sensitive. So the judges use their discretion on whether or not they want to televise the trial. It's so big that I think they should. You know, if we're looking at the Clancy case here in Massachusetts, even though the victims were children, it's still televised, you know, but every state operates a little bit differently as far as public access. Okay. So we will see. California, it's hit or miss. You know, I've done a few California cases on this channel. We did ASAP Rocky. That was interesting to say the very least. But there have been a few California cases that we've done. It really depends on the judge that you get and how far they're willing to go. As far as these pretrial hearings for the David case, they have not been televised. The day of his arraignment was televised. So I think it's also because of the media attention that's coming with it. But I know that David courtroom is facing a lockdown for sure, because I saw it coming weeks ago. And that's kind of why you guys haven't seen me talk about it in a while, because I want to be able to see it myself. I want to be able to pull the documents myself. I love to give you guys that level of reporting, because then you know I'm not making shit up. Like, that's why this channel rocks. I don't make shit up. We look at it together and I correct myself if I'm wrong. But I do like to be able to see stuff like this myself with you, explain what's going on accurately, and also pull court documents if I can, right? So that gives you a little bit of a halftime review on where we are. But yeah, otherwise, channel update. I did get contacted by ABC to do a documentary on another case that we've done on this channel. So stay tuned for that. I'll keep you guys posted as we go. But as far as travel for the month, I'm all locked in for KPG, but that might be the only thing if I have to fly to LA to do a shooting for that particular thing. That is what we are doing. All right, let's get back to Yella Beezy. I believe this hearing is wrapped up. We'll go to
For now, for the next hour.
You also want to- Your Honor, would it be possible for us to use the jury room just for us briefly to tell them what?
That's fine.
Thank you, Judge.
all right. Okay, so you see the brother there. He was walking out. That was the first pretrial hearing from last week. We will now proceed to the second one and see what else it is that we missed. And I think this is going to get more particular with Yella Beezy himself. But let us jump into it. Make sure the audio is good. All right. Let's go on in. We are behind the plexiglass again.
Okay.
And to give me a status today, what the DA is proposing to do, what the intent of that. It looks like maybe y'all are comfortable. Y'all may be seated. So we're still waiting on defense counsel on White.
Yes, Your Honor.
All right. I'm going to go in the order in which it was handed to me. So let's start with the defendant's motion for list of state's witnesses prior to trial. Has the state given a witness list?
We've not yet, Your Honor, but I will have it to the defense in the next few days. I'll be working, finishing it over the weekend.
Okay, by Monday. We should hand it over by Monday. That motion is granted. Defendant's request for notice of state's intention to use evidence of extraneous offenses at trial. Has the state had an opportunity to review that motion?
I'm sorry, Your Honor, which one was that?
The 404B, 609, 707, 3837, that extraneous.
Yes, Your Honor, the only two things that we'd have on the 803, 804, 902, since these are hard copies.
I'm not sure we're looking at the same motion. This was titled Defendant's Request for Notice of State's Intention to Use Evidence of Extraneous Offenses at Trial.
Correct, Your Honor. At the bottom of page 1, where it says rules 803.
Oh, okay, I see.
On the second page, that into the second page, as far as the priors, they are of course physical copies. And so if they want to schedule a time to come inspect the physical copies of the priors, the certified priors, I'm happy to accommodate them.
Okay, Ms. West, can you do that on Monday? This is Friday. Would you like to do that on Monday?
let me, I can see. I'm sorry, Your Honor, I'm naturally in Dallas County on Tuesdays, so I'm always here Tuesday, usually Mondays, Wednesdays, and Thursdays, I'm in other counties.
Okay. I'm ordering the state to make these available to you at least by Monday, so you can get with the state and determine whatever of the dates would be convenient for you. But the state will have it ready for you on Monday.
They're ready.
I'm sorry?
They are ready, Your Honor.
Okay, very good.
The next thing would be,
Let's put a date on Monday. Monday would be the 27th.
the one exception that I know that is not ready, and we're just waiting on getting it, is the defendant's federal prior from the Eastern District of Texas, and we are working on obtaining that. So that is the only one that we do not have back yet. Once I have that, though, I, of course, will accommodate to let Ms. West and her team come look at it. The only other thing I had as it relates to this motion is the 20-day notice. I believe the code asks for 10-day notice, but we will be filing our notice of extraneous on everything on Monday, and be providing that to defense via e-file.
Okay.
However, since there is a 20-day requirement on there, in case there were jail incidents or anything that came up in between the 20th date of trial, I just want to make sure that anything inside those 20 days that becomes known to us, any new events that may or may not come up, that we're not restricted just because of that 20 day.
You will not be restricted.
Thank you, Your Honor.
And Your Honor, could I ask whether or not the state, obviously they're going to e-file everything, which I think is appropriate, but if they would be willing to also send an email, just because there are a gazillion
Right.
things that are e-filed.
And that's been my practice on every single motion I've filed on this.
Okay. Motion to require our state to reveal agreements. Has the state reviewed that motion?
I have, Your Honor, and again, we just talked about this previously on Mr. Conway's case on the record just a second ago, or an hour ago. As it relates to any deal by the state, at this time, Your Honor, there's no deal between the state and any witnesses or co-defendants. Of course, I would make all defense attorneys and all defendants aware of any deals as it relates to any agreement or any law enforcement agency. I am requesting that information from the federal government and their prosecutors. If I get a response or receive that information, I, of course, will pass that along to the respective parties. However, that's not in my possession.
All right, that motion is granted. Motion for discovery of the arrest and conviction records of state's witnesses. Has the state reviewed that motion?
Yes, Your Honor, and again, we took this up briefly, again, on Mr. Conway's, and it's part of the agreed order that I had proposed to all the defense counsel that I would provide them with the NCIC, TCIC text, again, of any witness that I intend to call, and that information, if it were in our possession. Of course, I would do my due diligence,
Okay.
and turn over what we have.
All right, this motion is granted. The state will turn over to the defense any criminal history of its civilian witnesses and law enforcement witnesses, which the state is under an ongoing obligation to discover.
And again, just to be clear, Your Honor, because under number 1 on defense motion, it's asking the court to order us to examine the records of local law enforcement agencies, TCIC, NCIC, concerning arrests and convictions of each of its witnesses. Does that mean the court is ordering us to run each and every witness, including law enforcement, prior to trial, to actually run them.
Well, what I'm asking you to do is to turn over to the defense any criminal history that your law enforcement witnesses or civilian witnesses have.
Correct, and I just want to make sure that, because that is asking you, you're saying, but granted, are you ordering us, as in subsection 1 is ordering us to examine the records for every witness?
How would you find out the criminal history of each of these witnesses?
I mean, I can ask them, but I mean, that's what I'm trying to clarify on the record. Are you ordering us to enter every single witness, civilian and law enforcement, into these databases?
All the witnesses that you will be calling,
Correct.
if they have any criminal history, you are to hand it over to the state, however you discover it.
Oh, again, it just,
Which is what? By running their TCIC, NCIC? Is that how you would usually discover it?
that's what this, her motion.
But I'm
is.
asking you, is that how you would discover it?
We do not run law enforcement through TCIC, NCIC.
Okay. But if they do have a criminal history, how would you discover it?
I can ask them.
Okay. If they do have a criminal history,
Correct.
it's your duty to discover that and hand it over to the defense.
Okay.
That's my ruling. Motion for discovery of punishment evidence.
Your Honor, I'm generally okay with the motion. However, we would object on number 3, 4, 6, 7, requesting the names and locations of any witnesses. That raises the burden of the state and is outside of what the law requires of the state to actually provide. Defense has all the discovery in this case. The law only requires that we turn over the names of the witnesses that we intend to call.
May I respond to that, Your Honor?
Yes, you may.
I do anticipate that the state may call witnesses that they have either provided safe harbor to or are assisting. And therefore, there wouldn't be a way for our investigator to locate them, for us to potentially investigate and interview those witnesses. So I would ask that the court grant this motion as written and ask that the state provide us with the locations of its witnesses so that we can investigate independently.
May I respond?
Yes, go ahead.
Your Honor, at this time, there is not any witness that I believe that is under safe harbor or being protected by the state, either the state or the federal government. And if there were, I have a different argument that there would be a reason their location was confidential and being protected. But that is not the case. And again, that is requiring us to do something that is not required by law. I'm happy to provide them with the names of the witnesses. They have all the discovery, which provides even names and phone numbers. However, this asks for more than the law is required of us, and could potentially put a number of people at significant risk.
Right, the state will provide the names and the contact information, phone numbers of the witnesses that they intend to call for punishment evidence. And I mean, if there's a particularized need for the location, y'all can come back to me, and if maybe the state will broker a meeting. Okay?
Thank you, Your Honor.
So this is granted but denied as to locations of said witnesses, unless there's a particularized need and the defense meets that burden.
Yes, Your Honor, and just so the record is clear, even though that portion is denied, we are requiring that the state provide contact information.
Yes.
Thank you.
All right, motion for discovery. Has the state reviewed that motion, that document?
Yes, Your Honor, and I have a number of objections to it. Under section A, number 1, addresses is an objection, is my objection, is the same one we just talked about previously.
Okay.
Again, it's,
Court will make the same ruling. List of names and contact information other than addresses unless the defense makes a particularized need, shows a particularized need.
number 2, we agree with a list of names and addresses as it relates to expert witnesses. However, adding in the professions, the subject matter, and description of his or her contemplated testimony and his or her report. I'm okay with the report, but profession and the subject and description of his or her contemplated testimony is not what's required by law.
Does the state have any reason to not want to provide those?
Well,
The profession of the
I'm fine with the profession, but me writing down a description of the contemplated testimony, then I'm summarizing what this individual may testify to, and that puts me in the spot of creating a narrative, and I'm not the person testifying. I'm happy with giving the name and address. I'll even throw in profession. However, me
and the
writing,
subject of the testimony, not necessarily a summary. It's a subject.
that's fine. I'm fine with that.
All right.
Number 5, it's dealing with criminal histories, again, of each witness for the state. Of course, the court knows our position on that.
Yes.
Again, on number
So
6,
you have my position on that.
I'm sorry, Your Honor.
You have my ruling on that.
Yes, Your Honor.
Okay.
Again, I believe number 6 covers that as well.
Okay.
Moving on to these statements, I'm fine with everything up until number 11, which I just want to, 11, 12, and 13, I just want to make sure that it's on the record that we have provided these transcriptions for 11, 12, and 13. I don't have any problem with them. I'm just letting the court know that we have
Provided those.
complied with that. Yes, Your Honor.
And Your Honor, if I may, I just want to, I do know that I have received information as it relates to testimony at the grand jury and things like that. I would just want to make sure that the record is clear that if there's anything outside or in addition to what I've already received, that I want to make sure that that's, that the state is directed to turn that over.
Okay. The state will be ordered to hand those over. I mean, you're
I don't know.
under an obligation. Well, I'm not sure there's been any other grand jury testimony
There's been a number of people who testified, Your Honor.
since.
Yes, there have been
Okay.
a number of individuals who have testified in grand jury proceedings. All of their transcripts and the evidence that was presented in those, if there was evidence, has been turned over.
Okay. I guess I'm asking if there's been any more since then.
No.
Okay.
Under subsection C, we're fine with everything. Subsection D, again, Your Honor, a couple of these things I'm just objecting to because it's not required by law, and I don't know what some of these are. I mean, as far as the name and rank and badge number, I provide the name and badge number, and it'll be on my witness list. As far as the rank, that's so fluid, that could change, and I might not know what it is. I'll ask everybody what the rank is.
Name and badge number would suffice.
Thank you, Your Honor. The name and address of any person, including suspects in this case. So again, this is why I think the address thing is this is right on point, and I appreciate this being here. Like, it'd be like me providing the name and address of where Defendant Conway is currently staying. I am sure Mr. Shook and Mr. Guzio would have a huge objection if I were to provide that to other defense counsel, the actual address of where he's living. I'm sure he doesn't want it out there. So again, we're objecting to the address portion of number 3.
That's sustained.
And as far as phone numbers or contact information, I can't really get a contact number for co-defendants and stuff. I mean, I could ask Mr. Schutz to give me Mr. Conway's cell phone number and I can provide it to Ms. West, but
And I think, Your Honor, the way that it's written is I'm asking for suspects, which are different than co-defendants. And so I would be asking for, that's what we're asking for. And I assume that the court's ruling is going to be no addresses, just contact information.
Correct.
Yes, that, we don't have an objection to that.
and also, Your Honor, as far as requiring us to provide the name and address of any person, I'm happy to provide the name and contact of individuals I'm planning on calling. There's individuals that I'm not planning on calling. Again, goes way beyond the scope of what's required by law for me to track down all these people. I mean, they have an investigator. They can do their due diligence on a case too. As far as the individuals I'm intending on calling and the information that I have, I will provide it to them. I have no problem with that. But to make me say any potential person in the world, that would be.
Well, and I apologize, I don't mean to cut you off, sorry.
I mean, they have to do some due diligence on their own as far as witnesses. As far as who I'm going to call and who I'm planning on putting on the stand, I will provide that information.
Okay.
And Your Honor, it's just, it's not any person in the world that's associated with this case. It's very specific to interviewed by representatives of the state or law enforcement. But either way, I don't have any problem coming back to court if I'm struggling to locate someone that the state has provided me, coming back to the court to ask for assistance related to that. They have vast resources as the state of Texas, which are far beyond what any investigator that I have is capable of.
All right. Otherwise, my ruling on all the paragraphs here that deal with addresses of witnesses, my ruling is that the state should turn over the contact information, phone number, name. But if the defense has a particularized need for the address, then y'all can approach me, or you can sort it out between yourselves, right?
Thank you, Your Honor.
All right.
And those objections, Your Honor, carry on through number 8 of subsection D.
Okay.
Under subsection E,
I don't mean to interrupt, I just want to make sure that I'm understanding. You're saying for part 8, that obviously the court has already ruled they're not going to provide addresses, but are you having an objection?
This is pretty standard. I mean, like, they're going through a lot of pretrial stuff. Like, hey, if there's a witness on the stand, how do we get in touch with them? You guys have been calling her Judge Shaka Khan. Okay. Shika Iniem, I believe. But I do like her style so far. As we get closer to the Yella Beezy Mo case, we're going to see more of her. But this is one of the second parts of the hearing from last week. I have pulled up the motion so you guys can see what she's ruled on. She's already ruling from the bench. I do like that. Some judges will rule from chambers and put out their rulings afterward, or if they need time to take it under advisement, to do some research and make their decision, they'll go from there. But I am going to give you guys a synopsis in about 20 minutes about what the full hearing consisted of. So a synopsis of, okay, what were the motions, what did she rule on, and what we can expect moving closer to trial.
Objection to providing the name and telephone numbers of informants?
No, I think he's just talking about the
Address?
Yes.
Thank you, Your Honor.
Photographic evidence, defendant under subsection E, defendant moves the court to order us to produce and permit counsel to inspect the following designated items regarding photographic related evidence. In this case, on number 1, where it's laid out a photograph, videotapes, audio tapes, drawings, charts, and diagrams made by the state. If I'm making something, Your Honor, it could be my work product, and it could be things that I'm using for my own personal preparation of this case. So I would object to anything that I'm making outside of what is going to be offered at trial and for the purposes of an exhibit.
Right. This will not include work product by the state.
For the following E, we have no objection. F, I have no problem with defense inspecting physical evidence. However, they would need to, and I'm happy to put them in touch with Detective Barnes. However, I believe Detective Barnes or defense has his contact information. They would have to coordinate with DPD or the other agencies because we don't house the property here. So it would need to just be coordinated with the Dallas Police Department.
All right, so the defense will make that contact and schedule a date for whatever physical evidence you need to review.
As far as the test results, we provided all the test results, so no problem providing them with all test results regarding scientific evidence reports. That as far as things that were made by quote unquote experts, we have no objection with any of that under subsection G.
Under H,
Subsection 1, 2, 3. Subsection 1, 2, and 3 would all be, if it exists, it's already contained within the discovery that's been provided. I would ask for clarification on number 4. But the evidence of pertinent trait of character of the alleged victim of the crime which the defendant is charged.
All right, I'm not going to hold you guys. This prosecutor,
It's a little bit on the boring side, so we're going to speed him up to 1.25 speed
because I'm falling asleep over here, brother. Come on.
I need a little, I don't know what the defense wants me to say about the victim's character. It seems like an opinion question that I would be giving.
right. This is something that, if at all, it'll come through testimony.
What this point is asking for is if the state is in possession of evidence related to information that would fall under section 404B as relates to the victim, if they're in possession of that, then that be turned over to the defense.
What's the state's response?
We provided defense with a large number of ROIs and reports about this ongoing back and forth beef. In fact, this court has heard evidence of back and forth stuff. I'm going to run the victim's criminal history, even though he's deceased, and that'll be part of the stuff that we have, because I do know it's in there somewhere, I believe. As far as me providing pertinent traits of the victim's character, outside of witnesses who are going to testify to that, I don't know how I would even do that.
Well, I think a big part of what the state is alleging is that, and I think that we heard Detective Barnes talk about an alleged beef between various parties, and that there was a tremendous amount of testimony in that pretrial hearing about the decedent in this case and statements that he made, raps that he made, referencing firearms and killing people and all of that kind of thing. And the state is obviously in possession of it because they had a whole hearing about it related to a co-defendant. So it's referencing that type of information. They've already had a witness that has testified to a tremendous amount of information. So that's what we're referring to. We have ordered the transcript in that case, but those are the things that we're referring to.
And I believe the state, they've tendered all documentation and exhibits that would point to this, if I'm understanding you correctly. You're talking about bad acts by the victim?
Right, Your Honor. So I don't know if the state sent me their evidence that they introduced during that pretrial hearing. I perhaps need to search for it and see where I received that. When I say we ordered the transcript, I don't know if that's going to include all of the exhibits that were introduced.
It was uploaded about 2 weeks ago, Your Honor.
Okay, if you can re-forward it to me, that'd be great.
It's on texture. It's on texture.
Oh, okay.
And as far as, again, getting into the character stuff, I provided what's in my possession. I'm not going to go out and search down every YouTube blogger who was pro Yella Beezy and who was anti. But I provided what we have in our possession.
I'm not sure that it asked for anything other than what's in the state's possession.
Okay. Otherwise, so this number 4, do you want to revise that?
Man, we're going to be all up in evidence in 2026, 2027. I'm telling you guys right now, I was just in Not Williams chat talking about this. So many YouTubers And y'all saw it with Julio Fulio. They watch what we're doing online. Like they do. They do. Like even with the Tupac case, I have a guest. Ooh, you guys are not gonna believe who I got. But he might be testifying. So I'm like, man, you might have to come on after the trial because I'm not trying to get caught up in any of this bullshit. I'm not. But they're like, oh, YouTubers that are pro this person, pro that person, like they're catching on. Like LawTube has changed so much since I started. The fact that courts are actually watching what's happening online and distinguishing whether YouTubers are pro one group, pro another, and not pro justice is crazy work. It is insane. We are being surveilled highly, dear chat.
To read something else? For example, I mean, or do you want to withdraw that?
Your Honor, I'm happy to revise it
Okay,
to read, and I don't know if you want to, like,
go ahead, recite it.
okay. So we would, that we're asking for the state to provide evidence within its possession of character evidence of the alleged victim in this offense that would or could be admissible under 404A3A of the Texas rules of evidence.
What's the state's position? I'm sorry?
I'm fine with that.
Okay, very good. All right, any other comments or objections?
No, ma'am.
All right, that motion is granted. Motion in limine. This one's just titled motion in limine. I think I had a number. Okay, well, two motions in limine.
Your Honor, I haven't filed my motions yet regarding extraneous offenses, prior convictions, anything, so I'd ask that it be held, and if we need to take this up at a later time, we can.
Which motion in limine are you holding?
I didn't realize that it doesn't have it.
I have two in my hand here. One says, one has another header, prior convictions.
Okay,
Is that
so I
what you're
look at the
looking
other
at?
one. The one prior convictions, want to start on that one?
Yeah, the one that just, yeah, the one that says prior convictions.
Okay. I'm fine with this one because it's just, they're asking that nobody refer to anything unless a hearing is held outside the presence of a jury. I'm fine with, as it relates to prior convictions. As far as hearing on under subsection 2 for specific convictions or alleged violations, again, regarding hearing outside the presence of a jury, I'm fine with that. Extraneous offenses, when we go down to D on page 2. I have no problem not that these would need to be, like subsection 1 doesn't ask for a hearing outside the presence of the jury. I'm fine with subsection 1 if the defense wants to have a hearing outside the presence of the jury, which is in subsection 2, but not in subsection 1. So I have a problem with that. And additionally, to cross-reference another motion, the defense has also filed a motion to adopt motions, objections, and request for instructions of co-defendants.
Hold on, I think you're running ahead.
So I also want to make sure that I'm following. Are you under, in the original notes that we were just talking about, under B, which is titled extraneous offenses, and then point 1? Is that where you were just referring to?
Correct.
Okay, so this is just that we're requesting that neither the state, its agents, its employees, its witnesses mention, allude, or refer to any extraneous offense alleged to have been committed by Keyone White in the presence of the jury.
And I understand that, but also every other time, like in subsection 2 or on the previous page under subsection 1 and subsection 2 there, you asked for a hearing. On this one, you did not ask for a hearing, which is different. So I'm fine with
On
that.
which one?
Subsection 1 of B1. So I'm fine with that as long as it's subject to a hearing outside the presence of the jury.
Yes, so before any extraneouses are mentioned, let's have a hearing outside the presence of the jury, unless, of course, the defense opens the door
Certainly.
to specific extraneouses.
And I think that one of the big things that I am wanting to make sure we're all very clear about is because I'm not I don't know the specific list of potential, sort of statements or rap songs or Instagrams or whatever that the state may be intending to introduce. I don't know whether or not those things include any mention of extraneous offenses or.
I know this is a little boring, guys, but I have pulled up the Instagrams and all that stuff. We're going to look at that evidence together. This case is slated to begin in about 3 weeks. This is one of the final pretrial hearings. I think it is the final pretrial hearing. The judge does have something on the 21st to check in, but I am going to be completely pivoting to the not Courtney Clenny. I'm completely pivoting to the Tupac case. That's why we are watching this final pretrial hearing right now. Should be good for a few weeks for anybody interested in the Mo and Yella Beezy thing. I'm going to show you the evidence in a second, and we will see how the judge ruled on these final pieces before trial. So stay tuned. We got about, I'm going to say 20 minutes left. I have it on 1.25 speed right now. Reminder that the woman in the black right now is representing defendant White. Conway is Yella Beezy, and then we have defendant Brown as well. So you have some people that are going to trial together. You have some discussions about severance, but this is slated to begin at the end of the month. It will be televised like we're seeing right now. We will not see that with Dirk, and we are not seeing that with the David case. However, this is preliminaries for the end of August.
Bad acts or things like that. So those the motions kind of go together. And so is the court saying that even with that, before anything comes in, there will be a hearing outside the presence of the jury?
Well, I'm yet to make a ruling on certain extraneouses, which and so I think that's going to factor into what I will allow and what I won't allow. Yeah. So what specifically are you alluding to?
I want to make sure, and maybe the easier way to do it so that we can all be on the same page is once they file any additional notice.
QB, I can't with you today. QB, I can't.
Notices to us regarding extraneous, that all of the things related to extraneous, our motions in limine, et cetera, can all be ruled on at the same time, so that we all have a clear roadmap about what needs to have a hearing, what is just coming in, and that's all happening at one time as opposed to piecemeal.
Okay, and you do have the notice of extraneouses. You
What I
have not
understood-
notified. Oh, you haven't submitted that yet. You said you were going to
That's
do
what
that
I'm
by
gonna
Monday.
Correct.
Okay, all right. So once you exchange that information on Monday, Ms. West, if you need another hearing to talk about specific extraneouses on that list, then we can schedule a hearing.
Yes, and I anticipate we will, so I can reach out to the court at that time.
Okay. All right. Okay, so I have another motion in limine. Because the state had an opportunity to review that one.
And again, Your Honor, I will hold on this one because I don't think we can do anything until that's filed on Monday.
Does this still reference extraneouses? Is this the
Correct.
same motion, but just a different format, Ms. West?
What I was in conference with my co-counsel. What is the motion that you have pulled up in front of you?
There's one with prior convictions as a subheader. But
I'm gonna agree with the state and say, can we hold that? So that we can, again, just everybody be on the same page about what's gonna happen here and what's not.
All right. Defendant's motion to adopt motions filed in prior cause and co-defendant causes. Explain that, Ms.
Yes, Your Honor, I don't know that it's, this is sort of a catch-all. I know that there was a period of time where Mr. Ashford was lead counsel on the original murder charge. I don't know if he did anything. I don't know if he filed motions. I don't know about what may have happened. But because this is based on the exact same set of facts, I wanted to make sure that anything that happened or was filed or ruled upon in that murder charge carries over into this cause number. As well as anything that may have been filed in some of the other co-defendants that were originally charged with murder and then upgraded to capital murder. If the court made any rulings, if there were motions that were filed, because several of these co-defendants were originally charged with murder and were dealing with the exact same set of facts.
Okay, so you want to adopt the court's rulings regarding those co-defendants' motions?
As well as any motions within Kiwan White's original case number.
Okay, I don't think Mr. Ashford filed any motions, and I don't think the court has ruled on
So there's-
any. defense
Just so we're clear, Your Honor,
Mhm.
was that the defendant's motion to adopt motion? So I got two separate ones on motion to adopt motions. One's defendant's motion to adopt motions filed in prior cause and co-defendant cases, and another one that's motions to adopt motions, objections, and requests for instructions of defense. I don't know which one we're talking about.
We're talking about the one that does not mention objections and requests.
So, okay, so just as it relates to co-defendants, whether or not I have a problem with co-defendant language because there may be a reason it would be relevant, that the court might find that it would be relevant in this defendant's case, but maybe not in another defendant's case. So I think that in itself, just adopting motions.
Well, if they want to adopt it, I can't stop them.
Oh, sorry, that's the adopting the file of it. I'm fine with that. If they want to file all the same motions, I'm fine with that.
Okay. All right, so that's granted. All right, so the second motion to adopt motions, objections and requests for instructions of co-defendant. Does the state have any comments or?
That's where, Your Honor, I would take issue with a blanket of the court adopting the same ruling as it relates to this defendant as it might relate to a different defendant. So I think that would have to be a case by case basis, and that the court would have to evaluate it case by case.
Well, that you're probably right, but then I'm not defense counsel, and I can't strategize for a defense counsel. So if that's what they want to do, if they feel that's the best for their case, then the court will grant it. Is that what you're asking for, Ms. West?
Your Honor, and I want to make sure that I'm being very clear. What I am asking is that there be the rulings that come out of the court as relates to the individual co-defendants, that those be sort of as standardized as they can be. There are specific facts to my client that may be.
What do you mean sort of standardized?
So in other words,
I will only rule on specific motions brought forward by the co-defendants and their attorneys. I mean, I can't tailor make it for you or them. Depends on whatever they bring me. So if you're asking me to adopt my rulings on their motions, then that's what I'm going to do. I'm not going to go back there and say, well, is this going to benefit P1Y or, not?
I'm not asking the court to do that.
Okay.
As an example, there was an extensive pretrial hearing in Mr. Conway's case regarding the admission of rap lyrics.
Okay.
So what this motion is about, and what it's asking for is, for example, and I have no idea how the court is going to analyze any of that information, but should the court decide, for example, that rap lyrics are not relevant and they're overly prejudicial and they're not probative, if that's how the court rules, then we would want that same ruling to be able to apply because it's about rap lyrics and not necessarily the content of what's being said.
Okay.
That is what this motion is about.
Okay.
As an example.
Okay. And I don't see that the state can object to this.
Well, Your Honor, on that general, like, again, that is a specific example. This is a general motion.
And I'm treating this as a general motion.
Right, so as a general motion to adopt what would be
Y'all already know what the turtlenecks mean. We saw it in the YSL trial. We saw it from little boy Sean. We saw it in all the trials, okay? It's hide in the neck tattoos, all right? That's what it is.
on in Mr. Conway's case, we might want to approach and explain to the court or give examples of how something may be relevant. Again, as a specific example of the Conway hearing as it relates to rap, I understand that as it relates to those specific exhibits. As it relates generally, which this motion is, we would need to be heard as far as why things may be relevant in Mr. White's case if the court found that they weren't.
Well, absolutely. During trial, both sides will have to, make their arguments during cross or direct. And, this is just a specific example that she gave. But during the trial itself, counsel is going to have to object and raise concerns regarding whatever evidence the state intends to put in or whatever arises during testimony. Ms. West, that is your understanding, correct?
That is my understanding, Your Honor.
Motion for disclosure of expert witnesses.
And I'm sorry, Your Honor, are you ranking this motion then?
Yes, I am.
Okay.
Thank you. Motion for disclosure of expert witnesses.
Yeah, like the glasses look. Yeah, no, so there's definitely only 20 minutes left. I'm going to read you what a reporter in the courtroom saw as the motions that she granted and denied, and the ones that were approved, we're going to look at them. Like there's one that's like an Instagram post. I will show you guys what that Instagram post looks like, and I think there's like 2 others that are coming into evidence, and then we'll get up out of here for the day. I know some of y'all are at work and you're like, AV, no, don't leave me. Don't leave me. Listen, we got 4 weeks of a Tupac trial. Okay. We are chilling. We are going to be chilling. So don't fear, chat. We're gonna be here locked in for the entire month of August. It's gonna be insane. It's gonna be insane. But let's go back on in. She's wrapping up, and then we'll go into those rulings, the 3 pieces of evidence that are likely coming in, and we'll go from there.
On page 2, Your Honor, we would object to, I'm fine with name and address in a CD if they have one. I'll ask them if they have one. I've provided CDs on the people that I know have one. Under number 1, I'm fine with that. The subject matter of the expert's anticipated testimony, I mean, just a brief description, I'm fine with that. A summary of their opinions and conclusions, I'm objecting to that because, again, that puts me in a place of putting, making almost a record of what I believe their testimony is. And I would object to that because it's not required by law, and again, that puts me almost in a witness position. The basis and methodology used to reach those opinions, again, Your Honor, that puts me in a position of creating something. It's more than the law requires of the state. They have their names and their addresses and their CV if they have it. Number 5, I'm fine with any reports, notes, or testing results prepared by the expert. I'm fine with that, even though that's not required by law. Any documents, photographs, and data reviewed or relied upon by the expert, even though it's not required by law, I'm fine with that. I believe all of that is contained within the information they're providing. So I'm fine with it to the extent that it actually is provided by them. The expert's qualifications, including education, training, and publications, again, that I think falls under CD in subsection 1 and is more than the law requires. Number 8, any prior testimony by the expert in criminal cases, definitely picking that one as far as it is extensively more than the law requires.
And if I could just address that point specifically, it's written very oddly. It's just, usually on an expert CV, it'll say, I've testified, in 15 criminal cases. I understand that this reads as if I want the testimony that they gave in those other cases. Instead, I want notice of, like, this person has testified in Alabama, California, in 15 criminal cases.
It's not a requirement.
I'm asking.
If the state would be gracious enough to give that to the defense, if then that's fine. Otherwise, that's something that the defense can ask about, during cross.
Okay,
Of the
yeah,
expert.
Your Honor, I think on the CDs they have them listed, but I think I don't have a list of all that.
I've seen some that have it and some that don't. So,
I believe Dr. Nielsen and Lieutenant Lawrence had that last week.
okay.
So to the extent that I had that, of course I would provide it.
Okay. So I'm going to sustain the state's objections to number 3 and number 4.
And again, Your Honor, just so the record is clear, I'm not challenging the court's ruling. In number 4 specifically, this is what is the methodology, if any, applied that the expert used? I'm not asking for the state to make up a methodology. It's, for example, when you have a insanity case, there are specific methodologies that are used by experts to make determinations. That's what I'm asking for when I say that.
Underlying data that they
The
relied
underlying
on.
data,
Yes,
that
exactly.
kind of.
But as for how they applied the methodology or what they used, that's something that you will find out when the witness is on the stand.
Thank you, Your Honor. And then for number 3, I contemplated that a summary of the expert's opinion and conclusions is just something that expert would provide to the state and then would be sent to me. That's what I contemplated with number 3. So it's not something I'm asking Mr. Adams to create and form his opinion about what somebody else is saying, but just for them to say, this is generally what I intend to talk about, and that be forwarded.
The subject matter,
Your
The
Honor,
subject matter.
it just
which
briefly,
is number 2. Go ahead.
the law, there's a reason that the law has only the requirements of name and address when it comes to experts. There is another mechanism, and it's the appropriate mechanism to handle this, and that's to have a hearing. So that's why I'm objecting to all of that outside of what's required under the law, because if Ms. West wants that and defense counsel wants it, there's a mechanism by which to do that. We can have a hearing as for the experts, their qualifications, their background, what cases they testify. If they want to have that hearing, by all means, we can have those hearings to each and every expert. However, I'm objecting to all that is outside what's required by law.
Right. And I've sustained your objection. Other than that, the rest of the motion is granted. Motion for discovery of all information obtained by the police from the Crime Stoppers program.
Your Honor, if there was any, that would be contained within the discovery that was previously provided, so I've got no objection.
That's granted. Motion for discovery of exculpatory and mitigating evidence. Has the state reviewed that motion?
I have, Your Honor, and the only word, just because I'm very particular when it comes to words, just agents, generally.
Which paragraph?
Paragraph number 1, in the possession of its agents, and we're talking about agents of the state. Again, there's been a lot of talk about federal agents and stuff like that. I have no objection to disclosing any exculpatory or mitigating information, as well as all my requirements under 3914, Brady, and its probably.
Okay, that motion is granted. Motion for discovery and preservation of recorded incoming telephone calls and dispatch radio communications.
I don't know if that's asking me for a response, because I don't have any ability to go back and preserve 911 calls 6 years later.
Ms. West, would you explain that, this motion?
Okay, I mean, again, I appreciate that it's been 6 years. There was a re-indictment in 2025. It's not the defense's responsibility to preserve and collect evidence. And so this is to ensure that everything as it relates to radio traffic, 911 calls, communications between officers, everything that occurred on November 11, 2020, which is the subject of this trial, regarding communications between law enforcement, is preserved and turned over to the defense as required.
Does that clarify things for the state?
I think this would be a proper motion and something that the city's attorney's office would have to reply to, and it would need to be served on Dallas Police Department. To the extent that, and that's a motion for them to respond to. I've provided everything that I've received from Dallas Police Department as it relates to this offense back in November 2020.
I'm going to grant this motion. All those calls and communications, hopefully the state preserved all of that. All right, is that the extent of the defendant's motions? Did I miss any? Ms. West?
1 second.
Yes.
If I may,
Yes.
the court has heard I believe it was any agreements, the motion for any agreements by the state. And I just wanted to kind of expound in the hearing with Northeast Conway, as it relates to the rap theories, Detective Lawrence several times said that Darvarius Moore was a suspect, but was not charged. And I think our concern is that if there's any agreements or any action from the state part, that they're not pursuing an indictment on someone in response to that person cooperating with the state, we would like to know that.
Yes, and that's envisaged in the motion and in my ruling.
Okay.
Any agreements at all, any concessions made to any co-defendant?
Yeah, listen, all the day ones are popping in. Y'all are like, shit, I know you were live. God damn it, I gotta go back. Listen, this is just a hearing. You guys have time. Don't rush this, because this case is not starting until the 24th, but we need to do it. I hired somebody for my team because there's so many cases in August. So don't worry. If you feel like you missed anything, this one is not urgent. The Keefe D stuff is kind of urgent. But with this one, y'all can relax, watch it over the weekend. You know, I'm about to go through the motions that she just ruled on, but this is a pre-trial hearing from last week. We're going to look at some of that evidence again. But for everybody that's popping in, I see a lot of my day ones coming in. You guys are good. All right. Y'all are good. What we need to get ready for is this Suge and Tupac stuff. Oh my God. Wait till I break down this book for y'all. The Tupac trial is going to be crazy. I'm telling you guys right now, it is August. And then at the end of the month, this trial is where we're going to pick it up. But we're going to see if Keefe D is going to do it. There's rumors that plea agreements have been floated towards him. But Keefe D is so goddamn thick. I don't know if he's going to take it or not. I think he's going to be stubborn and want to go to trial and risk it. This month is crazy, chat. This month is insane. So we got about less than 15 minutes to go. I'm going to show you some evidence and we're going to wrap it up.
Or suspects that needs to be turned over to the defense.
And also, we just like an oral motion, Your Honor, that we have the ability to file additional motions if necessary.
Yes, you do.
Thank you.
Both sides there. All right, there anything else? Does the state have any motions at this time? I think I ruled on the state's motions.
You're all done.
Yeah, okay. All right. If there's nothing else, that concludes this hearing. Thank you. Devin Brown is next up.
I like the look of this attorney on the left. I'm not even gonna hold you. He reminds me of the YSL case. Man, there was that father and son team, the Silver Fox.
Yes. His attorney's here. Does the state have motions on Brown that they would like me to consider?
Next co-defendant. Man, y'all trying to turn the chat into Kalshi. I know we do polls over here, but y'all trying to, maybe I could figure out how to do that. Can we do a Kalshi group? Guilty, not guilty.
Yes. Thank you.
Oh shit.
All
Oh
right, both
shit.
sides ready?
There we go. There we go. All right. We got the defendant sitting down. It took a while to bring him in. We are in the back of the courtroom. This is why I can't stand that law and crime sometimes does not hire more people, because we're in the back of the courtroom behind plexiglass. And that's why it looks like we are in a fogged out Honda Civic from 1994 with smoke everywhere. That is the vantage point that we have in this courtroom.
Both sides ready? Thank you. Let's get on the record. This is cause number F2500177, style the state of Texas versus Devin Brown. Is that your name?
Yes, ma'am.
All right, will the attorneys announce their presence?
He cares for the citizen accused of.
Tommy, I'm state that.
Thank you. And Mr. Brown is charged by indictment with the first degree felony offense of capital murder for remuneration. And today is the pretrial hearing. The defense has submitted a document titled Defendant's Election and Omnibus Pretrial Motion. Has the state had an opportunity to review that motion?
We have, Your Honor.
Does the state have any objections to any of the requests made therein?
Under subsection 9, under exculpatory mitigating evidence or evidence inconsistent with guilt, of course, we would comply with all of our legal obligations and obligations under 3914, Brady, as it relates to any other law enforcement agencies or prosecuting offices that are from the federal government. We, of course, have made requests to them for specific things as it relates to witnesses in this case, and we will turn over those things that we receive from them. As it relates to everything that's in our possession or an agent of the state, of course, we will turn over that. I just want to make sure that's on the record. Of course, put that on the 2 previous defendants. Just want to make sure that I put that on the record as it relates to Mr. Brown.
All right.
As it relates to
That's granted.
Okay. And so 1 through 8, we're agreed on all those. Number 10, as it relates to disclosure and production of physical evidence, we're happy with defense reviewing and inspecting any and all physical evidence. We've just asked that they coordinate with the Dallas Police Department or the ATF to review it because it's not actually housed here in our office.
Okay, so the defense needs to review any or eyeball any physical evidence, make the scheduling, and meet up with the law enforcement or investigators and schedule a date to review that.
Yes, Your Honor.
All right, that's granted.
Number 11, my only problem there is on what the expert plans to testify on or about. I'm providing defense. I either have provided, and I believe I've provided all of the finalized reports, but I know I've also included drafts, but as far as what they're going to testify to is
I think that refers to subject matter,
just as far
on
as
what the expert plans to testify to or about. Subject
providing
matter.
just the reports. I mean, again, not me writing down and providing
No.
them. Okay, then otherwise,
That's granted.
Judge, on that issue, I just want to make sure, I'm trying to get no money. So we don't have no money to be trying to get all the transcripts from all this gang junk they were talking about the other day. I just want to make sure that the court will pay for a copy of those transcripts.
Texas wasn't lying. He said, Judge, we ain't got no money. We don't have no bread. What do y'all have me watching? I've never seen that in my life. A defense attorney look at a judge and said, Judge, we ain't got no money. It's been hard out here for a pimp. We don't have the money. Y'all asking for these discovery fees, the terabytes of information, all of that. I charge by the hour. The hour. We ain't got no money, Judge. We don't have it. He indigent. Okay, he indigent. He is in cuffs. You see him. He ain't like Yella Beezy in the turtleneck, in the suit, in the fitted suit. We ain't got the money, Judge. Oh, I've never seen that before. We gotta bring that back. Oh, we need to clip that. Judge, we ain't got no money. Let the brother go in again.
And meet up with the law enforcement or investigators and schedule a date to review that.
Yes, Your Honor.
All right, that's granted.
Number 11, my only problem there is on what the expert plans to testify on or about. I'm providing defense. I either have provided, and I believe I've provided all of the finalized reports, but I know I've also included drafts, but as far as what they're going to testify to is
I think that refers to subject matter,
just as far
on
as
what the expert plans to testify to or about. Subject
providing
matter.
just the reports. I mean, again, not me writing down and providing
No.
them. Okay, then otherwise,
That's granted.
Judge, on that issue, I just want to make sure, I'm trying to get no money. So we don't have no money to be trying to get all the transcripts from all this gang junk they were talking about the other day. I just want to make sure that the court will pay for a copy of those transcripts for my client, because I'm telling you, he ain't got no money.
You are retained, correct?
Yo, that was,
I understand. You can, we can talk about that.
well, I want to make sure that the court was well aware that he came to court us, let alone
Oh, you're doing
investigator.
this pro bono?
All
We
the-
are.
Yeah, basically, because we didn't anticipate, and we gotten, I don't know how many,
Oh, he mad that they pro bono. He said, yeah, basically, he ain't got no money. I got money to go pay for these damn transcripts. Yeah, we're doing this pro bono.
Terrors of discovery and discovery.
It's called
discovery.
terabytes.
Okay, I'm sure that the court was well aware that he came to court us, let alone, the
Oh, you're
investigator.
doing this pro bono?
All the, yeah, basically, because we didn't anticipate, and we've gotten, I don't know how many terrors of discovery and discovery.
It's called
discovery.
terabytes.
Okay, it's a lot.
Oh shit! He said, I don't know how many tariffs we got. No, Ninja, you thinking about money. It's terabytes. He said tariffs. He said tariffs, goddammit. This is a tariff. I had to pick up this client. He ain't got no money. He ain't got whoever that defendant is, he is cooked. I think that's Mr. Brown. He is cooked. If your lawyer gets up and says, Judge, we ain't got no money. It's not terabytes, it's tariffs.
All the information. It has nothing to do with my firm, so don't.
Okay. I will pay for the transcript.
Thank you.
All right. All right, go ahead, Mr.
Adams.
Adams, yes,
Thank
go
you,
ahead.
Your Honor. As it relates to number 14, criminal histories of witnesses, we've covered this previously. I know Ms. Evans and Mr. Harris were both in here as it relates to criminal histories. I believe Mr. Harris was actually a first assistant when they had to go down and fight this whole deal. So I think he's very right. We don't run law enforcement officers, but we will provide criminal histories of any witness that we intend on calling. And I will do my due diligence as far as asking officers about prior arrests and criminal histories that I intend on calling. But I know Mr. Harris was a good fight behind dealing that role on his first assistant.
Yes, that number 14 is granted, and the state will turn over any criminal history information of its law enforcement officers or civilian witnesses.
Again, regarding the last paragraph on page 4, regarding any deal, immunity, promises, compensation, rewards, we will of course comply with all of our legal ethics and allegations under 3914 Texas, as well as the professional conduct, case law, Brady, Giglio, and so forth. However, when it comes to things that may be in only the possession of the federal government, I am doing my due diligence to request all of that information or any potential evidence that is out there. And if I do receive any of it, I will, of course, turn it over to all defendants, in this case, in their attorneys. But going on to page 5 at the top, because it's a continuation on, we would object to a complete and exact disclosure of the agreement, including notes, documents, recordings, electronic communications, and records reflecting the agreement. Again, my objection is not regarding the state and the state's actors and state's agents acting on behalf of the state. My only objection is to those things to which I have access to. If I do receive them from the federal government, the U.S. Attorney's Office, the district judges over and federal court release them, I of course will comply and will turn over all of those things. But that is my only hiccup on that.
Yes, that's granted, so long as the state is making the inquiries and
Correct.
asking of the federal government, and if you do know that there are any agreements made by them relating any of these witnesses or co-defendants, then you will further investigate or at least let the defense know that this is information that is out there that needs to be developed.
Okay.
All right.
The only other thing, I think this one can probably be held off on for now, and I'll leave that to the defense counsel. It's number 19, a motion to suppress. We would just ask that they file a motion as to any hearings or motion to suppression hearings that they have. Or they
I'm trying to hold it in chat. The fact that he said, Judge, he ain't got no money. I'm working pro bono. You gonna have to pay for these transcripts. I've never seen that before. He ain't got no money. The tariffs, and it's not a tariff. It's a terabyte. What the hell? That was the funniest thing I've seen all week.
won't have, but
Yes, if there's any evidence out there that you feel should be suppressed, then you need to file a separate motion.
Yes,
And
Your
bring
Honor.
that to the courts, bring that to the court's attention separately so we can deal with that ahead of time. Otherwise, that's granted.
And Your Honor, if we may just make a leave as well to file additional motions after we receive the notice of extraneous that's going to be supplied. We may have an additional motion as it relates to Mr. Brown.
You may file whatever other motions you feel appropriate.
Thank you.
and I'll have their motion, their notice of extraneous on my day as well.
Okay.
Also, as it relates, just so that it's on the record, inspecting the priors and stuff like that, I know Ms. Evans didn't share as well, and if they want to schedule time for me, look at the priors and fingerprints and all that, by all means, they're in hard copy in my office.
Okay, and available as at Monday.
Yes, the only one that I don't have, as I stated on another record, or on the record of defendant White, would be his Mr. White's Eastern District prior. Everything else I believe I have.
Okay, is that the extent of the defendant's motion?
Defense counsel did file them in all of their cases, but I think just for simplicity, my position on all of them, on all of the defense cases would be the same. And if the court wanted to adopt that as cover all of his cases, I'd be fine with that.
Court will do that. Court will adopt all the court's rulings on this motion through the defendant's other cases. Okay. Other than the ones noted, the defendant's omnibus pretrial motion is granted.
Thank you, Your Honor.
You're welcome. Now let's go over to the state's motions and notices. State's first motion in limiting, has the defense had an opportunity to review that?
We have, Your Honor.
Any objection?
No objection.
That's granted. State's second motion in limine. Has the defense reviewed that motion?
We have, Your Honor. We have no objection.
That's granted. State's motion to require the defendant to be photographed.
Your Honor, we have no objection to that.
That's granted. Motion to disclose experts.
Your Honor, we have no objection, and should we have an expert, of course, we will supply the information.
That's granted. Okay, and then there's this agreed order.
I think that's covered by all of the previous motions that have been granted.
Right, I would say so. So the court will decline to sign that order.
No, I withdraw.
Okay, very good.
I have not filed it anyway, Your Honor.
Okay.
Never.
Yes.
Thank you.
All right, are there any other motions?
None from the state, Your Honor.
Member of the defense.
So the only, one caution, I don't know if they're claiming that my client is a rapper. It's not a very good one. But I just want to make sure that we adopt those motions from co-defendants regarding the hearings on the gangster music and all that stuff.
Okay. All right, that's noted.
Thank you, Your Honor.
Thank you. If there's nothing else, that concludes this hearing.
Thank you.
Thank you.
Okay. I believe that does it for this hearing. So, okay, let's get to the good stuff, which is the things that the judge ruled on that are actually coming in. So, for everybody that's been coming in, you guys have been asking me a lot of questions. I've been in the chat trying to answer them, but man, August is crazy. August is insane. We are on July 31st. Number one, the biggest piece of news today is Courtney Clenny, the OnlyFans model. She is absolutely guilty. There ain't no way. Ain't no way she's not guilty. She is so guilty. Okay? So guilty. The girl's in the elevator she's just molly-whopping the guy. I don't know why he stayed with her. There were so many pieces of evidence that showed that girl was abusive. And it's like, that's not something you see all the time. But, I really wanted that one to go to trial because, like, you're abusing a black man. And I wanted to see what was going to happen with that. She was really confident. But her parents got arrested in that case. They were trying to take the young man. After he died, they were trying to break into his laptop. The defense attorneys were trying to break into his laptop too. That case was crazy. It had happened in 2022. So in 2026, she's been sitting in jail for 4 years. she took a plea deal today. I was like, I did not see that coming. I learned it on Cat Now Williams' channel about like 2 hours ago, but now it is complete national news. So didn't see that one coming. So that's your first piece for the day. Next, we have Keefe D. I'm going through this thing. I'm almost done. He is so cooked. There's literal confessions in this book. His name is right here. This Tupac trial is crazy. The shell casings and this, I don't know what he said in the 2008 interrogation and the 2009 interrogation, but we are going to trial on August 10th. He better not plead out to. I swear to God, if this ninja plead, he better go to trial on the 10th. So we are going to sit here like Holland. Okay, everybody? Everybody cross your fingers. We're going to sit here like Holland and just meditate to get a new trial on the 10th. That's the next one. The last, I checked the docket this morning. All looks okay. I've heard that he has been presented with plea deals and has rejected them. His defense attorney is very solid and actually likes to take on high profile cases like this, even though he's lost all of the damn motions, all of them. This week, last week, beginning of the month, the first of the month, terrible. It's not looking good. Keefe D's going to lose. Can they get him on murdering Tupac 30 years later? I don't know. But I'm so excited and fascinated with that one. So throughout the next week, we will sprinkle in some live streams, sprinkle in just some self-snitching from Keefe D. That one's going to be a lot of fun. It's going to be really fun. Because the prosecution said, they actually said this in the last hearing. The last hearing where all you guys were here. The prosecution said, if Keefe D didn't write this book, he probably would have never got caught. So shut up. Shut the F up. Shut up. Why did you have to go on Vlad TV in the Art of Dialogue? And Vlad read. Oh, wait till I show you guys that interview. Vlad read it just like me. Vlad read it. He was sitting there taking notes. I've flagged some of these pages. You mother effers done killed Biggie too, because they didn't pay the money for Tupac. That's some bullshit. Where's the love? Like, Keefe D, what the hell? That, I think, is going to be a hilarious trial. So I'm really looking forward to it. If he takes a plea deal, he has colon cancer. His son was in the courtroom on Tuesday about to wild out. And I'm like, law and crime. You're in Yella Beezy courtroom and you're in the back behind the plexiglass. But meanwhile, y'all could have been watching this brawl that was about to happen at the Tupac trial on Tuesday. But you weren't there. Law and crime, what the hell? Get back into the urban courtrooms, goddammit. We need you. This is making me want to start my own law and crime firm. Just hire a bunch of camera people and we just cover the trials that matter to us. You know what I mean? Shit. Get in there. I needed to see that. I couldn't see anything. Then I've been waiting for them to post the damn footage all week and they didn't. So I finally put a video out last night. Watch it because YouTube hates me right now. They're just like, oh, AV, you've been gone for a week. You took a week off. No one is going to watch your videos. No views. It's amazing. Okay. Now back to the subject matter of this video. We just watched the hearings for about 2 hours. That was the full hearing from last week. Now I'm going to bring you guys to the Twitterverse so we can see what this judge actually ruled upon. What I can tell you based off of the notes that I've taken so far is this trial is set to begin on the 24th of August. Okay, that is an interesting date with some co-defendants because you started at the end of August, and we saw this last year with Donna Adelson and the Adelson case. You go into the Labor Day holiday, And depending how fast the prosecution can get to it, and when you have co-defendants, it can take some time. We just finished the Julio Fulio case, and that took us about a month and a half, almost 2 months. Okay, so when you have multiple co-defendants, it can take some time. So that might take us into mid-September for the Yella Beezy case. All right. Now, lyrics brought in as evidence when it comes to Mo's murder, gunned down on the highway. A surgeon, we just learned that a surgeon is also suing because there was an assault for shooting a neurosurgeon that day as one of the victims. Bryson, boom, Paul is one of the main people and sources I trust and have trusted for years when it comes to reporting on hip hop cases. I believe Bryson did work for Law and Crime at one point, but solid reporter. This is the only key person that I'm going to be following for this one. Last week, he does give us a breakdown of how, and y'all need to stop calling her Judge Shaka Khan, okay? Judge Chica filed her ruling with the Dallas County Court clerk on the music events and interviews. So let's go through it real quick. I'm not going to show you the full 14-page document, but here are her rulings. The assault of Roy Lee Pate, denied. That's not coming in. There was a 2018 shooting and death of Pate, or Roy Lee Pate. I might be saying that wrong. That's not coming in. That's denied. There was a shooting of defendant Beezy himself. That shit's denied. He can't even bring it in and use it as evidence. Shooting of Trap Boy Freddy Sprinter, Van and Associates. That was 2 months later in 2018. That's granted. That's coming in. 2019, July, unruly citizens concert, denied. She denied a lot of stuff. In 2020, Conway assaulted Mo's manager. That's denied. I don't know why she would deny that. Shooting of Moore and Trap Boy Freddy, granted. Okay, so we got two things granted, and they are surrounded on Trap Boy Freddy. Next, 2020, September, decedent ambushed at V Live Houston. Granted. Okay, we got another one. October, Halloween 2020. The IVA Center performance, that's denied. 2019. Ooh, I just made a figure for you guys. Shooting of D1 Spikes, granted. Ooh. Shooting of James Bubba Browning, granted. Shooting of Robert Goya, granted. Okay, so those were all events, shootings and the like. So we start with that section. Next, what I really love that Bryson does is he now talks about interviews. There were a series of interviews where this case was talked about in depth. 2018, Conway interviews with the Louisville Police Department in the hospital, partially granted. Okay. 2018, 2 weeks later, Breakfast Club interview, granted. A week later, 97.9, The Beat interview, granted. 2019, DJ Vlad interview, denied. Vlad is protected. 2019, a few months before, Kim Capone News interview, granted. Okay, so you don't get the Vlad interview, but you do get a Cam Capone News interview. Social media platform, reputable. I've used it. I've seen it. That's coming in. Now, so that was the interview section, and we just came up from the top on the shooting section. We are now going to come down to social media posts. So, Yella Beezy had an Instagram live post after Unruly Citizens, that event that was denied. Okay. Yella Beezy's Instagram live post, day of Mo's murder, granted. Yella Beezy's Instagram live post with Trap Boy Freddy granted. Mo's Instagram live post after the concert, so you see Yella Beezy's denied. Mo's version of that is also denied. She wanted to keep that out for some reason. Mo's Instagram live post, Mo3, sorry, after rainwater assault denied. Then you have Trap Boy Freddy's Instagram post the day of Mo's murder granted. Okay, so this is all Instagram. 1, 2, 3, 4, 5, 6 of them that she evaluated, and this one's 50-50. So we have denied, denied, denied. Yeah, you are just about at, yeah, you're 50-50 with this one. 3 granted, 3 denied. Let's talk music. Mo's 219, that song denied. Yella Beezy's Hitters granted. Yella Beezy's Keep It in the Streets denied. Trap Boy Freddy and Yella Beezy's On Your Head partially granted. Yella Beezy's and the LA Lakers freestyle unreleased track Take 3 granted. Yella Beezy's Gassed Up granted. Trap Boy Freddy's Hypocrite granted. Trap Boy Freddy's Laugh Now granted. Trap Boy Freddy's Shirt granted. Trap Boy Freddy, the judge is on your head. Trap Boy Freddy. She looking at these songs and she like Trap Boy Freddy. Granted. Okay, so these are a collection of actual incidents that have taken place. So we just talked about that. The interviews, what's coming in, what's not coming in. The social media posts, what's coming in, what's not coming in. And then the songs themselves. And that's the big portion of this stream, right? Is lyrics used as evidence. And let's talk about that for a second. We saw lyrics used as evidence in the YSL trial. And that's really where this national conversation started to happen about it. And in that case, it really involved the Bloods, the murder of Peanut in the Atlanta area, and Lil Woody. Y'all remember that? Lyrics used as evidence, music videos used as evidence, people ironically looking like Nut getting offed in a music video. Like we saw that. Really big showcasing of this in the Julio Fulio trial. Lyrics used as evidence, but that's drill rap. You see a back and forth between Fulio and you see the back and forth between Young and Ace. And that kept going back and forth. And we were playing that in the courtrooms. And the jury had to decide, was this a gang thing? Was it back and forth? Can we use this as evidence? If we're in cemeteries rolling on graves and all of that, is that evidence? If it's a music video? Or on the other side, if you're in a golf course, like who I smoke? You know what I mean? Like you hanging off the side. Is that evidence? I never thought when I went to law school, because there's not a section in at least First Amendment law was probably one of my favorite classes. I should probably email my professor. Y'all need to add a section about music and maybe literature. I mean, this is starting to get insane, but it's riveting material, right? So that's where we are with how the judge ruled. Now, here is one piece. I hope I. Yeah.
Yo.
He YN. He a little YN.
Fuck y'all got going, man.
Mo 3. Sorry, guys.
I mean, motherfucking boom. sir.
This is the YN cam. What is he saying though? Like,
What are y'all talking about, man?
oh, it's
Up
people
here,
in
you know
the
what I'm
chat.
saying? Jamming this new music, you feel me?
Oh, it's people in the chat.
Working like a motherfucker. God damn me. God damn me.
Ooh, the internet came after his ass.
Once my niggas smoke right out the jar. Count this motherfucking money up till I can't count no more. That real
Oh
talk.
God, why you gotta play
I
music?
ain't talking about nothing. I let my M's talk. Dugging in the G5 jet, nigga, about to have sex soon as we live, dog. All these op nigga pissed off. Fat pockets on call, wins low. Nigga, I don't need no shit.
Yeah, Mo3's chat came after
bitch.
him. Was like,
All right, bitch. Say no. Say no
Ninja
more. Say less.
Justice.
Say no more. Say less.
All right, and then the women come up after. I don't know whose screenshot that was, but wow. Okay, so what does it say here on the side? It says state prosecutor Tommy Adams filed a motion to secure attendance of out-of-state witness with Dallas County Clerk on Tuesday the 28th. The prosecution asked a California court to compel hotel security chief Tim Glenn to testify at Yella Beezy's capital murder trial, arguing his testimony and hotel records are essential to the case. Glenn is head of security at the Valorian Hotel. Yella Beezy arrives in California to record music on November 4th, according to attorney Toby Shook, while examining Detective Eric Barnes. Yella Beezy was in California, where he appeared to host an Instagram Live shortly after Mo3 was shot on Interstate 35 on November 11th, 2020. I mean, Mo3's chat came for him. Like, what? Okay, so that's one of the biggest things. Let's keep going. Bryson, you guys please show Bryson some love. You know, DallasObserver.com. He is contributing. He's covering some other cases, but I've followed him for years, especially with the Melly case. He's a great reporter. Next, let's look at this one. It says 3 songs entered into the Yella Beezy murder for hire trial to be heard by the jury have been a boost in streams on Spotify. So the songs we were just talking about, people are listening to on goddamn Spotify. They've gone up. What? People are listening to them again. Okay, well, I think people are listening out of curiosity. It says the 3 songs entered into the Yella Beezy murder for hire trials have seen a boost on streams on Spotify after the judge's ruling on Monday. Mo3's 219 has seen a 0.2% increase in streams since Monday. Yella Beezy's Keeping in the Streets saw a tiny one. Mo had more. Mo had more. An increase in streams since Monday. Yella Beezy and Trap Boy Freddy's On Your Head from Monday 2020. My Brother's Keeper, which only present Yella Beezy's rap in the trial as Trap Boy Freddy's parts are redacted from being heard by the jury. Okay, if the song is redacted, chat, that means that the jury's not going to be able to hear the full song. So people are curious and they're going to listen to it. It has seen a 0.5% increase in streams since Monday. Casey on the track, producer of On Your Head, on his music being put on trial in the Yella Beezy case. So it looks like he has a quote here. As the man I've grown to become now, I feel very weird feeling to see something I created to be one of the topics of a very serious case that's going on. Yella Beezy, real name Marquise Conway, capital murder trial begins on August 24 at 8:30. Whoo-wee. It's gonna be a big one, chat. It is. I'm staying on KPD's neck first. Man, somebody from Death Row hit me up, was just like, I want to come on the channel. I said, oh my God. And then ABC News hit me up on another case. I'm like, oh my God, this is August is crazy. August is crazy. But anywho, let me read. I only got very few interactions today on some super chats. Just D hits me every single time. Shout out to Deanna, been with me for over 2 years. Says, AV, what's good in the chatterhood? We are back, guys. I'm gonna be doing a few shorter videos, catching up on everything over the weekend, and then the 4th next week, I think it's Tuesday. We will be Tuesday, Wednesday. We'll be back for KPD, and then on the 10th, it's time for the Tupac trial. We ready? We are ready. Thank you so much. But that is what's happening in the chatter. Hood drops $2 super chat here. Says, RIP Mode 3, stop the genocide. Yeah. That's what makes this stuff tough. Sheba says this is a death penalty case. No, it's a capital murder case. It's Texas. They ain't playing in Texas. They are not playing in Texas. So August is a crazy month, even just in the realm of hip hop. You're starting the month with the Tupac murder trial. You're going to end the month with 2 on the same week. And that is Lil Durk, Yella Beezy, both murder for hire trials. Crazy. You can't make it up. And I mean, these 3 are pretty much all locked in and confirmed. I'm a little nervous about KPD, but it's right here. I mean, you just self-snitched on you. So this is Master Splinter. Mastery. My God. This is not even digital evidence. It's in print. Let me get off of here, man. Let me get off of here. I'm going to keep going in. Anyway, dear viewer, you guys stay safe. It is Friday, wherever you are. I hope you're enjoying your day. If you are interested in this case, I'm going to be doing more on it. Like I said, I hired somebody particularly to help me with this one, since we have 3 trials happening at once this month. So we did hire some help. I did create a playlist for all things Yella Beezy. So whenever I do have an update or a video that comes out, you guys will be notified. So please make sure that you have your notifications on, that you hit the like button, that you're subscribed, all of those things. If you want another voice, a legal perspective, I actually did go to law school. So I'm not going to just give you guys a biased perspective. I'm going to do my best to keep it focused on the law and teach you what I know as we go. Like I said, many cases covered on this channel: YSL, ASAP Rocky, Karen Reed. Man, there's just been so many over the last 4 years, but I'm really excited for the month of August. All right, my friends, David's ass. Wait till we go to trial on that one. Taz is him, comes in. Listen, I've been wanting to tell you guys about Taz and the goats, but he pops in when I'm about to get off. So anyway, y'all stay safe out there. See you in the next one. Oh, yeah. Real quick, before I go. Julio. One of my favorite cases to cover. Little boy Sean. Little boy Sean. But I do want to quickly touch on this. Everybody is asking me how Lead is doing. He's doing great. We have been corresponding over email. I'm going to see him in a few weeks when I'm in Atlanta, and we're going to break bread and hang out. But he's doing great. Y'all don't worry about Lead. He's been doing he's a big boss now. He's almost at 700,000 subscribers. Bro, 700,000 subscribers is crazy work to me. When I first started podcasting with him, he was my size. So I'm just, I'm so proud of him and everything that he's accomplished here on YouTube. He gets views on like body cam stuff, but Lead is fine. Like he be emailing me, and y'all know that Lead voice. Like you just hear it. He's like, "AV, goddamn it!" like, it's just Lead. He's just crazy. He's just crazy. And y'all remember, like the OGs remember, if you found me on his channel, y'all remember all them uncomfortable faces I used to make as he would just say wild shit. Like just oh my god. But Lead is Lead is leading. He is doing his lead thing. I'm just really excited to see him, and I'll report back to y'all. But I'm sure he's fine. He be taking his time off. He'll get his little million views for the month. Like I'm going to the sauna, and just start relaxing. Like you don't see him for a month. The mendacity. Man, we have had so many jokes over the years. I was looking back at some of the old footage because he went and took it down because he big time now. We had over 200 episodes, and some of them were just so funny. So funny. So anyway, I will keep you guys posted on how he's doing. But we're in touch. We're in touch. That's my guy. You guys know. But all right, y'all. Y'all have a wonderful night. Stay safe out there. See you in the next one. Bye.